and Letitia George on behalf of the Office of the Public Defender.
We're starting with interpreter cases.
Good morning, Your Honor. Jaime Sotomayor, certified federal interpreter, already sworn. 1 second while I connect.
Thank you.
I can't find misdemeanor.
The interpreter is connected, Your Honor.
Thank you. Sir, please tell me your name.
Carlos Manuel Torres Razúa. Razúa.
Carlos Manuel Torres Azua.
You're here in 21 CF 14714, charged with aggravated assault with a deadly weapon and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. All right, sir, your bond on count 1 is $5,000, count 2 is $500. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Sí.
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement, but you cannot coordinate that with the victim. You cannot possess or consume any alcoholic beverages. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Jessica Angeli Criollo Silva.
Jessica Angeli Criollo Silva.
You're here in 21 MM 8058, charged with battery dating violence. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, when setting bonds, they would have you take into account that there allegedly was a weapon used.
I wondered why this was arrested as a battery and not a felony. But since it was,
It does not appear she has any criminal history, Your Honor. Should you just take that into consideration?
all right, ma'am, your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You can't return to the victim's residence for any reason or be within 500 feet of the victim's residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. I believe in this case, I need the interpreter to be on the overhead speaker and not connected to the headset.
Yes, ma'am.
Thank you so much. Good morning, sir. Please tell me your name.
Antonio Zamora.
Do you not need the services of the interpreter?
Yes.
¿No necesitas intérprete?
Sí. Sí.
Okay.
Yes. Yes, I do.
Okay, thank you. Sir, you're here in 21 MM 8045, charged with battery domestic violence.
Está aquí en el caso 21MM8045, agresión en violencia doméstica.
I'm going to appoint an attorney to represent you.
Voy a nombrar un abogado para que te represente.
While you're in the courtroom today, I need you to look at me or this wall to your right. Do you understand?
Y mientras estés en sala el día de hoy, me tienes que mirar a mí o a la pared que está a tu mano derecha. ¿Entendiste?
Yes.
Yes.
And you have to answer out loud.
Yes.
Y tienes que contestar en voz alta.
Thank you. Good morning, ma'am. Do you wish to testify today?
Buenos días, señora. ¿Usted quiere dar testimonio el día de hoy?
Sí,
Yes.
Please raise your right hand to be sworn.
Pues por favor, levante su mano derecha para el juramento.
ok.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
¿Usted jura que dirá la verdad, toda la verdad y nada más que la verdad con la ayuda de Dios?
Sí,
Yes.
Please state your name for the record.
Por favor, dígame su nombre para el récord.
mi nombre es Alicia González.
My name is Alicia González.
You can put your hand down, ma'am. I'm going to ask the prosecutor if she has some questions for you.
Muy bien, puede bajar la mano y le voy a pedir a la fiscal que me diga si tiene alguna pregunta para usted.
Your Honor, state has no questions. Ms. Gonzalez is the witness in the case, not the alleged victim.
Muy bien, su señoría, la fiscalía no tiene preguntas porque ella es testigo en el caso, no es la alegada víctima.
Let me ask, does the defense have any questions for her?
Le quiero preguntar a la defensa si tiene alguna pregunta para la señora.
No, Your Honor.
No, su señoría.
All right, ma'am. What is it that you want to tell the court this morning?
Muy bien, señora. Entonces, ¿qué es lo que usted le quiere decir al tribunal esta mañana?
Buenos días, lo que le quiero decir al tribunal es, yo soy la mamá de Antonio Zamora.
But what I would like to tell the court is that I am Mr. Antonio Zamora's mother.
Ok,
Ma'am, I'll ask that you speak in short sentences just like that for the interpreter.
Le voy a pedir que haga oraciones cortas para que el intérprete pueda traducir
Ok,
como hicimos
gracias.
ahora. ¿Está bien?
sí,
Very well,
con
thank you.
mucho gusto.
I will gladly do so.
Thank you.
Eh, lo-
Adelante.
ok, espero la pregunta.
So, do I wait for the question?
There are no questions.
Yes,
What, you tell me what you want me to know.
ok.
No pregunta. Solamente dígame qué es lo que usted quiere que yo sepa.
Yo quiero, señora jueza, con todo el respeto, que usted sepa que en el día de ayer, cuando sucedió el evento en mi casa, yo estaba presente y yo me puse entre medio de mi esposo y mi hijo. Y le
What I
pedí,
would like the court to know is that yesterday I was present during the event and I stood between my husband and my son.
le pedí a mi esposo de favor, porque yo tengo una condición médica bien delicada de diabetes y presión, que no
And I asked my
peleara con
husband,
mi hijo. A mi esposo le
Please,
pedí eso.
because, un momento. So I asked my husband, please, to not fight with my son because I have a medical condition. I have diabetes and high blood pressure.
Lo que pasa es, señora jueza, que yo tengo un negocio y mi hijo me está ayudando en el negocio y mi esposo no quiere y provocó la pelea. Llamó a la
And what is
policía.
happening, un momento, what is happening is that I have a business establishment and my son helped me at that establishment, but my husband does not want him to do so. So he caused the fight and he called the police.
Yo me desmayé y mi hijo fue a auxiliarme, a darme agua y a levantarme. Y le
And I
dijo,
fainted, and my son came to my aid to give me water and to get me off the floor.
y le dijo a mi esposo, mira Freddy, mi mamá tiene 55 años, tú tienes mi edad, porque yo soy 20 años mayor que mi esposo.
And he told my husband, look, Freddie, my mother is 55 years old and you are my same age because I am 20 years older than my husband.
No pelees conmigo, por favor.
So please don't fight with me.
Puso las manos y Freddy empezó a hacer push, como a querer dar puños.
And my son raised his hands and Freddie started to like push him and shove him and to throw punches at him.
Llamó la policía.
Then he called the police.
Cuando vino la policía no dejó hablar a mi hijo. No,
And then when the police arrived, they didn't let my son talk.
no dejó que yo diera un testimonio diciéndole yo, explicándole yo que buscaran a alguien en español y el policía
And
no quiso.
the police officer didn't allow me to give him any testimony. I asked for somebody who spoke Spanish to be brought over by the police, and the police officer refused.
Cuando la policía arrestó a Antonio,
So then the police arrested Antonio
que se lo llevaron,
and they took him away.
los dos policías se quedaron allí y ninguno de los dos quisieron a llamar a nadie en español.
And the two police officers remained there with me, but neither of them wanted to call anybody who spoke Spanish.
Tuve que decirle yo, yo voy a llamar a las 911 y yo voy a llamar a un policía porque yo estoy en todo mi derecho de dar mi testimonio.
So I told them that I was going to call 911 myself because I know that I have a right. I have my full right to provide my testimony.
Lo que pasa es que Freddy habla mejor inglés que yo. Yo entiendo algunas palabras, pero todo no. Y lo dejaron expresarse a él y a mí no me tuvieron en cuenta.
Freddie speaks better English than I do because I understand certain words and there are certain words that I can say, but I can't express myself and Freddie does. So they allowed him to express himself completely.
Yo no sé cómo funciona la ley, pero yo creo que una persona, si está en un evento donde sucedió un acto, yo creo que la persona está en todo el derecho de dar su testimonio.
I don't know how the legal process works, but I believe that if a person is present when an event took place, that person should have the right to say everything they know about that event and provide testimony.
Y es por lo que de aquí yo me voy a dirigir a la corte a ponerle una orden de restricción a mi esposo que llevaba 10 años con él, porque yo no quiero otro evento, me está perjudicando mi salud.
And this is the reason why from here I will go directly to court to get an injunction against my husband, whom I have been with for years, because I don't want things to escalate any further.
All right, ma'am, you can do that. You'll have to go to the courthouse downtown.
Muy bien, usted puede hacer eso, pero tiene que ir al tribunal en el centro de la ciudad, el edificio.
Sí, muchas gracias.
I want you to know.
Yes, thank you very much.
I want you to know that the law enforcement officer wrote in his affidavit that he did, in fact, ask your son if your son wished to speak with him, and he did record what your son said.
Que el oficial le preguntó a su hijo si su hijo quería decir algo, y su hijo lo dijo, y el oficial escribió lo que su hijo dijo.
Pero yo creo que, señora jueza, con todo respeto, yo creo que yo soy una testigo principal porque yo estaba en el medio de esta situación evitándola y yo tengo derecho a dar mi testimonio.
But with all due respect, I believe that I would be the main witness in this whole situation because I was right in the middle of the situation trying to avoid it, and I believe that I have the right to give a statement and express my opinion.
Ma'am, it's not about a right to express your opinion. Law enforcement tries to interview witnesses at crime scenes.
Muy bien, señora, pero el asunto no es el tener el derecho de expresar un testimonio y una opinión. Los oficiales intentan tomar versiones de los testigos en las escenas.
However, in this affidavit, the law enforcement officer says that you kept getting in between him and your son.
Sin embargo, en esta declaración jurada, el oficial dice que usted continuaba interponiéndose entre el oficial y su hijo.
And actually physically blocked his path.
Eso es mentira.
Y que físicamente bloqueó al oficial.
Just a moment, ma'am. Let me finish explaining.
Okay.
Permítame explicarle, pero espera un momentito en lo que termino de explicarle.
This is what's in the probable cause affidavit.
Eso es lo que aparece en la declaración jurada para causa probable, para motivo fundado.
Pues,
Ma'am, let me finish.
Sorry.
Déjeme terminar.
Sorry.
I wasn't there.
Yo no estaba allí.
I'm just telling you what's in the affidavit.
Yo solamente le estoy diciendo lo que aparece en esa declaración jurada.
Based on what I'm reading,
y basado en lo que yo he leído,
law enforcement tried to fully investigate, including with you.
Los oficiales intentaron investigar por completo, incluyendo con usted.
But the perspective of the law enforcement officer seems to be you were obstructing the investigation.
Pero desde la perspectiva del oficial, parece ser como que usted estaba interfiriendo, obstruyendo la investigación.
However, I am confident that the state attorney's office
Sin embargo, yo me siento confiada de que en la fiscalía
will be very interested in hearing your testimony.
van a tener mucho interés en escuchar el testimonio de usted.
The only thing we're doing today
Y lo único que estamos haciendo hoy
is I reviewed the probable cause affidavit and find probable cause,
es que yo estoy revisando la declaración jurada para causa probable y estoy encontrando causa probable.
and I'm going to set your son's bond at $500.
Y le voy a poner una fianza a su hijo de $500.
And Mr. Zenora, your conditions of bond are you can have no contact with the victim,
Y le voy a explicar al señor Zamora que las condiciones de esa fianza son que no puede tener contacto con la víctima,
you can't possess a weapon, firearm, or ammunition,
no puede poseer arma de fuego, municiones ni ninguna otra arma peligrosa.
do you live at this residence?
Usted vive en esa residencia,
With my mother.
But do you?
I live
pero usted vive con su mamá.
I live, yes.
So you do live there.
Yeah, with my mother.
Does the victim live there?
Yes.
All right.
It's not a big deal.
At this time, you must maintain a separate residence
Muy bien, pues en este momento el señor Zamora tiene que mantener una residencia por separado de la víctima.
I was gonna do that. Yeah.
Okay. You can return one time with law enforcement to gather your belongings,
Okay.
Y puede regresar en una sola ocasión acompañado por las autoridades.
and then don't go back
Yeah.
Y entonces no puede regresar
until another judge changes my order.
Okay.
hasta que otro juez cambie esta orden.
So I can go only to pick up my stuff, right?
With law enforcement.
With
Y solamente puede ir acompañado de la policía para recoger sus cosas.
okay. Okay.
Don't go by yourself.
Okay, good.
No vaya solo,
That violates my order and you can be arrested.
Okay. Okay.
porque eso sería una violación de la orden y lo van a arrestar.
Yeah, I will.
This sounds like a family situation. It might be complicated. I don't know if the state of Florida is going to prosecute this case.
Esto suena como que es una situación familiar, aunque algo complicada, y a mí no me parece que la Fiscalía de Florida vaya a proceder con este caso.
So, hold on, Mr. Zenora, get in touch with your attorney right away.
Yes.
Así que le voy a pedir al señor Zamora que se comunique con sus abogados inmediatamente.
And ma'am, when you go downtown to file for an injunction, you may want to make an appointment at the state attorney's office.
Y señora, cuando usted vaya al edificio de la corte a solicitar la orden de protección, el interdicto, asegúrese de comunicarse con la fiscalía.
Ms. May, do you have a phone number you can give her?
Le voy a pedir a la fiscal que nos dé un número de teléfono.
Yeah, sure. I can give her a card with also the case number.
Okay.
All
Y
right.
le vamos a dar una tarjeta que tiene el número de teléfono.
Pero la fiscalía, ¿para qué?
Why do I need to go to the state attorney's office?
So this is the state of Florida versus your son. That's who's prosecuting him.
Porque este caso es del estado de Florida en contra de su hijo. O sea que el estado es el que le radica los cargos a él.
Ok, una pregunta más, por favor.
One more question.
La policía, yo estoy en todo mi derecho de dar mi explicación. Yo llamé al supervisor después que pasó este evento para hacer un reporte y me mandaron a que tenía que ir a donde estaba el alguacil y explicara. La policía está diciendo mentira y yo voy a llevar esto hasta las últimas consecuencias porque soy honesta y levanté mi mano derecha y estoy diciendo toda la verdad.
So what I wanted to say is that when we are done, I am going to go to the authorities. I'm going to go to the police office. I'm going to provide a complaint because I have been honest. I have been telling the truth, and I believe that my rights were violated, and I need to take this further.
Okay, you can do that.
Thank
Muy bien.
Good luck, ma'am. Good luck, sir.
Thank you, Mr.
Yes,
Le
yes, sir.
deseo buena
Good
suerte.
luck.
Así que buena suerte. Eso es todo.
Buena
señora.
Sir, please tell me your name again.
Por favor, su nombre, una vez más.
Carlos Manuel
Acusado.
Torres Azúa.
Carlos Manuel Torres Azúa.
All right, you're here because a witness in the case has just shown up to court.
Usted está aquí porque el testigo en este caso se acaba de presentar.
Let me ask, did you wish to testify this morning?
Le quiero preguntar al testigo, ¿quiere dar testimonio el día de hoy?
Sí, solo vengo porque quiero retirar todos los cargos contra él porque realmente no me siento amenazada.
Yes, I just wanted to say that I want to withdraw all charges against him because I honestly don't feel threatened at all.
All right, let me ask the state if they have questions for you and explain that's not how this works. The state of Florida is going to decide if they're going to charge him with a crime.
Déjeme pedirle entonces a la fiscal que le haga unas preguntas porque así no es como funcionan las cosas. El estado de Florida, la fiscalía de Florida es quien decide si se radican cargos o no.
Okay.
Ms. May, go ahead if you have questions.
Yes, Your Honor. Good morning. Can you please state your relationship to Mr. Torres?
Sí, buenos días. Por favor, ¿me puede indicar cuál es la relación de usted con el señor Torres?
El señor Carlos Razua es mi novio, es mi pareja, vivimos juntos hace un año. Y
Mr.
pues,
Carlos Azúa is my domestic partner. He's my boyfriend. We have been living together for a year.
And you stated that you're not afraid of him?
¿Y usted dice que no tiene temor de él?
no, nunca lo he tenido.
No, I never have.
Do you believe drugs or alcohol were involved in this incident?
¿A usted le parece que hubo alguna droga o alcohol envuelto en este incidente?
Sí, veníamos llegando de la discoteca y veníamos ebrios los dos.
Yes, we were coming from the disco and both of us were drunk.
And do you want to have contact with him while this case is pending?
¿Y usted desea tener contacto con él mientras el caso está pendiente?
Oh, sí, yo quisiera porque yo había pedido una orden de alejamiento contra él, pero yo se la quiero quitar para que regrese a la casa porque yo la verdad yo no trabajo y yo no puedo pagar la casa, entonces yo me voy a regresar a mi estado.
Well, yes, and I had also filed an injunction against him, which I want to withdraw because, I want him to come back home because I can't pay for the house by myself and I don't want to go back to where I'm from.
That's all I have, Your Honor.
All right, any questions from the defense?
Muy bien, ¿alguna pregunta de la defensa?
No questions, Your Honor.
No hay pregunta, su señoría.
Your Honor, state would ask that all the previous conditions that you've already placed on Mr. Torres remain in place, even given the victim's testimony.
Voy a solicitar que por favor todas las condiciones que se le impusieron al señor Torres permanezcan en efecto aún a pesar del testimonio de la víctima.
Given the allegations that are within the affidavit of not one, but two deadly weapons.
Y dadas las alegaciones que aparecen en la declaración jurada de que no había no solo una, sino dos armas mortíferas envueltas.
Anything from the defense?
¿Algo que tenga que decir la defensa?
No, Your Honor, if there's an active injunction, I just ask that the no contact remain in place for now.
No, su señoría, pero hay una orden de protección en efecto y vamos a pedir que la orden de no contacto permanezca en efecto por ahora.
I will do that. Thank you for coming this morning to testify.
Lo vamos a hacer así, pero muchas gracias por haber venido esta mañana a dar su testimonio.
My order will remain in place.
La orden va a permanecer en efecto,
Mr. Torres, you're not allowed to have any contact with the victim.
así que el señor Torres no se le ha permitido tener ningún contacto con la víctima.
You must maintain a separate residence, and I'll still allow the one-time return with law enforcement to gather your belongings.
Tiene que mantener una residencia por separado de la víctima y le voy a permitir que regrese en una sola ocasión acompañado por las autoridades para recoger sus pertenencias.
You can't possess any weapons of any kind or alcoholic beverages.
No puede poseer armas de ninguna clase ni bebidas alcohólicas.
That order will remain in place unless and until another judge changes it.
Esta orden va a permanecer en efecto hasta y si acaso algún otro juez la modifica.
Good luck to both of you. Thank you for coming.
Así que buena suerte para ambos, pero gracias por venir.
Yo tengo una pregunta más.
I do have one question.
Yes.
¿Qué día
adelante.
podrá salir él? Porque yo tenía mi vuelo hoy a las 2 de la tarde para mi estado. que me voy hoy. Entonces yo quería saber qué día va a salir él, porque yo la verdad tendría que dejar las llaves de la casa con alguien.
I would like to know what day will he be able to get out of jail, because I have a flight going back to my state at 2 p.m. today, and depending on when he is going to come out, I will have to leave the keys with someone or somewhere.
So I gave him bond. Whenever he posts that bond is when he'll be released.
Yo le impuse una fianza. Cuando él pueda pagar la fianza, será liberado.
Ok, ¿de cuánto es la fianza? Yo la voy a dejar pagar antes de irme.
How much is that bond? Because I'll pay for it before I leave.
5,000 on count 1 and 500 on count 2.
Son 5,000 en el cargo número 1
Hold on one second, let me check.
500 en el cargo número 2.
That's right. That's right. So he has to post that bond to be released.
Y tiene que pagar esa fianza para poder ser liberado.
Ok, gracias.
All right.
Very well, thank you.
Good luck to both of you.
Buena suerte a ambos.
Ma'am, tell me your name again, please.
Dígame su nombre una vez más, la acusada.
Jessica Angelique Criollo Silva.
Jessica Angelique Criollo Silva.
This is 21MM8058.
Este es el caso 21MM 8058.
Sir, do you wish to testify this morning?
Caballero, ¿usted quiere dar testimonio el día de hoy?
Sí.
Yes.
Please raise your right hand.
Por favor, levante su mano derecha.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
¿Usted jura que dirá la verdad, toda la verdad y nada más que la verdad con la ayuda de Dios?
Lo juro.
I do.
Please state your name for the record.
Muy bien, puede bajar la mano, por favor, su nombre completo.
Eddie Vizcaya.
Eddie Vizcaya.
I'll allow the prosecutor to ask you some questions.
Muy bien, la fiscal le va a hacer unas preguntas.
Good morning. Can you please state your relationship to the defendant?
Buenos días, ¿me puede decir qué relación tiene usted con la acusada?
Éramos novios.
We were dating.
Are you afraid of her?
¿Usted le tiene temor a ella?
No, pero
Well, no, but
Has anything like this ever happened before?
algo como esto ha sucedido anteriormente.
no.
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Si sucede algo como esto o algo peor, ¿usted se sentiría cómodo, se sentiría confiado en llamar al 911?
Sí.
Yes.
Do you believe drugs or alcohol were involved in this incident?
¿Usted cree que en este incidente estuvieron envueltos algo de droga o alcohol?
No.
No.
And do you want to have contact with her while this case is pending?
¿Y usted quiere tener contacto con ella mientras el caso está pendiente?
No.
No.
That's all I have, Your Honor.
Muy bien, pues eso es todo lo que tenemos, señoría.
Any questions from the defense?
¿Alguna pregunta de la defensa?
No questions, Your Honor.
No hay preguntas.
Thank you for coming.
Muy bien, pues gracias por haber venido.
Ma'am, all of the conditions I previously ordered will stay in place.
Muy bien, todas las condiciones que yo le ordené a la acusada anteriormente van a permanecer en efecto,
Including you can have no contact with the victim,
incluyendo que no puede tener contacto alguno en lo absoluto con la víctima.
not return to his residence for any reason,
No puede regresar a la residencia de él por ninguna razón.
not possess any weapons, firearms, or ammunition.
No puede poseer ninguna arma de fuego, municiones ni ninguna otra arma peligrosa.
Thank you for coming. Good luck.
Your Honor, you also have the
Así
condition,
que,
I'm sorry, you also have the condition that he's not allowed within 500 feet of the victim's residence or work.
She is not.
sí, ella no tiene la condición de que no puede estar 500 pies de la residencia ni del lugar de trabajo de él. Dice que no.
All right. Good luck.
Así que muchas gracias y buena suerte.
I believe that's all we have for the interpreter at this time.
Thank you, Your Honor. Have a good day.
Thank you. You as well.
Your Honor, Julio Castro Phoebus, refuse.
I'll find his refusal a willing waiver of his appearance today. This is 12 Okay, I'm sorry, 20 CT 1239. It's a warrant out of Seminole County with no bond. I'll appoint your office, Ms. George.
Yes, Your Honor.
Paul Clark is mental health.
What? No action. I can't know those dates. One more time, please.
Paul Clark, mental health.
21 MO 1312, Ms. George. I'll appoint your office.
I'll waive the appearance, Your Honor.
All right, there is probable cause. This is bond 250. I'll stay the bond at 250 with a do not return.
Jennifer Rosado is mental health also.
21 CF 14707, I'll appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
There is probable cause. Bond is $5,000. No contact with the victim, no weapons, firearms, or ammunition. Maintain a separate residence, one-time return with law enforcement. Any other conditions the state would request in this case?
No, Your Honor.
Good morning, please tell me your name. 21 MM 8032, you're here charged with disorderly intoxication. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, I reset this from yesterday because the offer was a withhold credit time served to resolve the disorderly intoxication.
I won't accept that, counsel, and I'm going to revoke his out on bond case.
Okay, Your Honor.
All right, sir, your bond is $250. You can't return to the scene for any reason, have contact with any witnesses in the case. You can't possess or consume any alcoholic beverages. And at this time, I'm revoking your bond in 21 CF 8899. Yes, sir. You have a question?
Yes, ma'am. Do I go home or
You can't go home today. I revoked your bond. You're out on bond for a violent offense. And the allegations in this probable cause affidavit have to do with some erratic, possibly violent behavior. So at this time, I'm revoking that bond. So on that green piece of paper is a phone number for your attorney. You want to call them right away. Good luck.
And we're already appointed on the out on bond, correct, Your Honor? If we're not appointed, I just asked.
If you're not,
Thank you. Sorry.
I am appointing you.
Okay,
The
perfect.
PDs have been appointed.
Okay, perfect.
Gracie Wells, refused.
I'll find that refusal a willing waiver of her appearance today. Ms. George, I'll appoint your office. These are out on bond, I'm sorry, these are out of county cases.
Yes, Your Honor.
CF 15006846, 2000466, 15019050, and 1600669. In all of these cases, there's no bond. We'll notify Polk, Seminole, and Lake counties that she's here. Please tell me your name.
My name is Luis Garcia.
21 CF 14719, you're here charged with child abuse. In 21 CT 1983, you're here charged with driving while license suspended or revoked. At this time, I'll appoint an attorney to represent you in both of these cases. Ms. George, did you wish to be heard?
Yes, Your Honor. As to count one, the child abuse, I would ask that you find no PC, but find PC for neglect of a child. Instead, there were no injuries to the child in the arrest affidavit, and a neglect of a child, the state has to prove that there was willful, culpable negligence or failed to admit or provide the victim with care, supervision, or services, and failed to make reasonable effort to protect the victim. And neglect of a child is without great bodily harm, permanent disfigurement, or permanent disability. Here, the child was in the car. He was allegedly drinking. He grabbed the child out of the car, but there is no indication that the child was hurt. And for child abuse, you have to have an intentional infliction of physical and or mental injury upon the victim. And that act could have reasonably expected to lead to physical or mental injury. And we don't have that in the arrest affidavit, Your Honor.
What says the state?
Your Honor, the state has no objection to the court finding PC for child neglect. I believe Ms. George is correct. that this was improperly charged as abuse and should be child neglect, which is 827.03 sub 2 sub D as in dog.
I agree. I reviewed the affidavit before court this morning, and I will do that. Sir, I find there is probable cause to charge you with child neglect. Hold on one moment. There is also probable cause for the driving while license suspended. At this time, your bond on the child neglect is $10,000. On the driving while license suspended, it's $500. With special conditions, you can have no contact with any minor child under the age of 18. You cannot possess or consume any alcoholic beverage. You'll be subject to random alcohol screens.
Is that in both cases, Your Honor?
Yes, that's in both. You must comply with any plan set in place by DCF. Are there any other conditions the state would request?
No, Your Honor.
You can't drive a vehicle. All right, good luck, sir. Did you get the statute? Please tell me your name.
Preston Schofield.
You're here in 21 CF 14730, charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. At this time, I'm going to appoint an attorney to represent you in this case. There is probable cause. Are they bringing in a witness in this case? All right. Sir, while you're in the courtroom, I need you to look at me or that wall. Do not look at the witness. Do you understand?
Yes, ma'am.
Thank you. Good morning, ma'am. Do you wish to testify this morning?
Yes.
Please raise your right hand.
Please swear to tell the truth, whole truth, nothing but the truth, so help you God.
Yes.
Please state your name for the record.
Marlena Diane Adams.
Ms. May, any questions from the state?
Yes, Your Honor. Good morning, Ms. Adams. Can you please state your relationship to Mr. Schofield?
That is my boyfriend and the father of my child.
Are you afraid of him?
No,
Has anything like this ever happened before?
not like this.
Can you explain what you mean by that?
Possessions weren't broken.
I didn't hear that. What?
Nothing like the other person's item wasn't broken. Like it
Oh.
hasn't escalated to that.
Have you had arguments that turned physical before?
No,
Do you believe drugs or alcohol were involved in this incident?
no,
And if anything like this or anything more severe ever occurred in the future where you felt threatened, would you feel comfortable calling 911?
if it happened like this, then no, because I don't believe I should have called the police as soon as I did. I was just nervous because neither of us live here, and I didn't know anybody for miles, and he didn't know nobody from miles, and I just wanted him to be safe. And I didn't want me to be in danger. I didn't want him to be in danger. I didn't want the argument to happen. I just wanted us to have time together because it's been a little stressful. The having the baby, jobs, things that have happened with him personally, and everything has just, on my end, it's been a little stressful. It was my birthday yesterday. I was stressed out. He was supposed to come. We made a plan for him to come on Sunday. Then he said he didn't want to come till Tuesday because he didn't get paid till Tuesday. And we were arguing. Well, we were going back and forth we weren't arguing. We were going back and forth because I told him it was fine. Like everything was taken care of. He doesn't have to worry about having the money, that we'd figure it out together. And so I didn't even know if he was going to come on Sunday, but he did. I picked him up. We went there, and had an argument. Just had an argument. Got out of hand, and I just don't think I should have called the police as soon as I did.
Part of the question was if anything more severe ever occurred, or if you ever did feel threatened, would you feel comfortable? If you ever felt that you were.
Oh, yeah.
And would you like to have contact with him while this case is pending?
Yes.
Right. That's all I have, Your Honor.
Anything from the defense?
No, Your Honor. I would ask for no hostile contact order. Given
No
the-
what?
Given the victim's testimony here today. It does not appear he has any criminal history. The arrest that shows domestic battery was when he was 17 years old. So he has not had any type of domestic history since then. So I'd ask that you take all of that into consideration. And the fact that he has community ties and everything. He's currently working, so I just actually take all that consideration and give him a no hostile contact order.
He has community ties where?
He lives in Daytona Beach. He's been there for over a year.
So not here.
Not here. I mean in Florida, sorry, Your Honor.
I see.
And they currently have 2 children together, Your Honor.
Your Honor.
Anything from the state?
Yes. I do see what defense is talking about, a 2014 juvie agbat from Marion County, which I believe was approximately when he'd be about 17.
It was an
However,
aggravated battery?
That's what I have on CCIS, Your Honor.
Okay.
However, there apparently was also a 2021 Flagler DV that occurred approximately in September.
Oh, I couldn't see that, Your Honor.
Do you have the victim in that case?
There was an announcement of no information. I believe the victim in that case is also Miss Adams, Your Honor.
All right, thank you. You didn't ask for pretrial release?
No.
All right. Sir, your bond is $2,500 on count 1, $500 on count 2. With special conditions at this time, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. Do you still have belongings at the Avanti, what's the name of that hotel?
Avanti Palms Hotel.
Do you have belongings there?
No, I grabbed all my stuff.
Okay, all right. So don't go back there. You'll have to maintain a separate residence from the victim. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with her. Do you understand?
Yes, ma'am.
All right. Good luck. Thank you, ma'am, for coming. Good luck.
Can I ask a question?
Yes, ma'am.
So then we can't talk.
No, he can't talk to you. Not at this time.
And so then how much bond has to be posted for him to be released?
So I gave him bond at $2,500 on count 1 and $500 on count 2.
The full bond.
So that's between him and a bondsman. I can't get involved in that.
Am I allowed to ask him a question?
No, he can't have any contact with you now.
Okay.
Good luck. Please tell me your name. 21 CF 14731. Sir, you're here charged with child abuse. I'm going to appoint an attorney to represent you. There is probable cause in this case. There's also additional crimes that weren't charged that are alleged in the affidavit.
Yes, Your Honor.
Additional charges.
There's several allegations in the affidavit that would give rise to additional charges, but you were not arrested on those. So at this time, I'm only setting bond on one count, which is child abuse. At this time, sir, your bond is $20,000 with special conditions. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
20,000?
Yes, sir. That's your bond, but you understand what no contact means.
So that's $2,000?
That's between you and a bondsman.
Okay, but hold on.
Your Honor, would you be willing to lower the bond amount? He hasn't been in trouble for 11 years.
I would not at this time. You'll have to file a motion in front of his trial judge.
Thank you.
Sir, you can have no contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You must comply with any plans set in place by DCF. You can't return to this scene for any reason or be within 500 feet of the victim's home or school. Do you understand that?
Yes, ma'am.
Good luck, sir.
Just got one thing. Just got one.
How are you?
Sir, you can say anything you want, but everything you say is being recorded and can be used against you later. You understand that?
In the affidavit.
Hold on one second. Wait. Do you understand that it's being recorded and can be used against you later? Okay, before you say anything, do you want me to give you a moment to talk to your attorney about it? Okay, I'm going to give you a moment. Talk to your attorney first.
All right. Thank you.
Yes, sir. Good luck. Call your attorney right away, okay? Please tell me your name.
Erin Renee Weaver.
21 CF 14732. You're here charged with battery on a person 65 years of age or older. There is probable cause. I'll appoint an attorney to represent you. Your bond in this case is $10,000. You can have no contact with the victim or the witness. Do you understand what no contact means?
Correct. I do live with her.
You don't now.
Okay. Yes, ma'am.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess a weapon of any kind, firearm, or ammunition.
Yes, ma'am.
At this time, I'm revoking your bond in 21 CF 1956. Did I say no alcohol? You may not possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens.
Correct. Okay. Ma'am, what's revoking?
It means you're currently being held at no bond on your out on bond case. So you want to call the number on that piece of paper and have your attorney file a motion in front of your trial judge to get you a new bond.
Okay.
And if we are not appointed, Your Honor, I'd ask that we be appointed.
I'll do that.
You already are.
You already are, okay. Good luck, ma'am. Please tell me your name.
Beth Marie Alvarez.
You're here in 21 MM 8040, charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, Your Honor.
And actually, I'm looking at her record, which includes a prior failure to appear, prior probation violations, many out-of-state convictions. I'm going to change that bond to $1,000 instead of $500, but all the same conditions still apply. Good luck, ma'am.
Will you lower it if you place her on pretrial release as well?
I will not, for the reasons I stated. Looking at that record, it concerns the court that she may or may not come back.
Yes.
That's why. Please tell me your name.
Johnny Butler.
21 MM 8043. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. While you're here in the courtroom, I need you to keep looking at me or look at this wall, but don't look at the witness. Do you understand? Thank you. Ma'am, do you wish to testify?
Yes, ma'am.
Please raise your right hand.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Ashley Christine Orsini.
Thank you. I'll allow the state to ask you questions, Ms. May.
Good morning, Ms. Orsini. Can you please state your relationship to Mr. Butler?
He's my fiance.
Are you afraid of him?
No.
Has anything like this ever happened before?
No, there was no altercation yesterday. That was the problem. Somebody else called. I don't know. The window got broken in the morning when we woke up. And I guess they must have thought maybe we were arguing, or I don't know. Somebody called and they just showed up. I tried to tell the officers that there was no argument, no conflict, no nothing, because we were going to church later. And for some reason, they didn't listen to me.
Do you want to have contact with him while this case is pending?
I do want contact.
That's all I have, Your Honor.
Anything from the defense?
No questions, Your Honor.
All right. Thank you. You can stay there while I finish addressing the case. Hold on, give me a moment. All right, at this time, sir, your bond is $500. With special conditions, you can have no contact with the victim in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim.
Yeah.
I'll order that you must comply with any plan set in place by DCF. I'll further order that you can have no unsupervised contact with any minor child under the age of 18, and you can have no contact with any witness in this case. Do you understand? Yes, ma'am. Did you have a question?
Yes, ma'am. They're saying I'm the victim, but I'm stating nothing happened. What it was is somebody else calling on a misunderstanding what they thought happened. So for no contact.
Ma'am, this is a court of law.
I know. I'm sorry.
I'll ask that you please watch your language.
I'm so sorry. I'm so sorry. I'm so sorry.
I understand what you're saying here today, but I'm reading the affidavit, and the affidavit says very different things than what you're saying. And there's an independent witness who says very different things from what you're saying, including that the witness heard your children yelling, "Stop, Daddy, stop." That concerns this court. So at this time, my orders will stay. Good luck, ma'am. Good luck, sir. Please tell me your name. You know what, actually, also, I'm gonna go back to that case. Give me 1 second. For the record, in the case, State of Florida versus Johnny Butler, 21 MM 8043, I also should state for the record that the court got up and walked to where I could see the victim, and I did observe the cut and the bruise on her lip that was being covered by her mask. That's consistent with what was in the probable cause affidavit. All right. All right, I'm sorry, sir. Tell me your name one more time. Thank you. This is 21 MM 8048. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Good morning, ma'am. Did you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Jeanette Casamajor.
Does the state have any questions?
Yes, Your Honor. Good morning, Ms. Casamajor. Can you please state your relationship to the defendant?
I'm his wife.
Are you afraid of him?
No, never.
Has anything like this ever happened before?
No, he's the sweetest guy. My husband is the perfect guy. He was just emotional yesterday, and he's great to our children. He's wonderful. He loves me. He adores me. He was just emotional on Sunday. He just was mad because I didn't want to talk to him the whole day, but I wish to have contact order with him. Because I don't feel any harm against him at all. This never happened before. I mean, we've been together for a long time, and he was just emotional. I feel safe with him every day, all night.
Do you believe drugs or alcohol were involved in this incident?
No, not my husband doesn't do those.
And do you want to have contact with him while this case is pending?
Yes, because we do have to have contacts due to our business, our jobs, our career, our life. We do.
All right, that's all I have, Your Honor.
Thank you. Any questions from the defense?
No questions, Your Honor.
All right.
I would
Thank
ask
you,
for
ma'am.
sorry.
Go ahead.
I would ask for no hostile contact order, given the victim's testimony here today and the fact that he has no criminal history. I would ask that you take that into consideration. And if you place him on pretrial release as well to monitor the situation, if anything occurs, he'll be brought back here and potentially held at no bond, Your Honor. So I ask that you give them the chance.
What says the state?
Your Honor, state's concerned regarding the affidavit or the allegations that are in the affidavit, including there being an independent witness who allegedly observed the incident, at least in the car portion of the incident. So at this time, state would ask for no contact. I believe a cooling off period may be the best, and allow this to be readdressed in front of Judge Shoemaker at a later time.
I agree with that at this time. Did you ask me for bond or pretrial release, Ms. George?
Bond, Your Honor. I was just saying if that would help the contact issue.
All right. At this time, sir, your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You can also have no contact with a witness in this case. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Why can't he have...
Just a moment, ma'am, let me finish. Were the children present, Ms. May?
Yes.
Do you see that?
I did not make note of it within the affidavit, Your Honor. I do not.
Oh, no,
All
that
right.
was the other case.
No, our children don't live with us.
Okay. Ma'am, did you have a question for me?
Yeah, our children doesn't live with us. He's never been violent in front of our children. This is his first time. He was emotional. He never been to jail. I don't know why there's a no contact because I am married to him.
Ma'am, I'll tell you why I ordered no contact. I understand what you're telling the court here today, but I'm reading the affidavit, which includes the testimony of an independent eyewitness who explained to the law enforcement officer that this was a pretty violent incident. And so I think that at this time, it's safer for both of you if you take a break. So he may not have any contact with you. That includes over social media, texting, phone calls, no contact at this time. His attorney can file a motion in front of the trial judge, and that judge can change this order, but until a judge does, he may not have any contact with you. That's why.
Okay, and what about the state, are they prosecuting the case or?
That's up to the state of Florida. I can't tell you that at this time.
Even as a first offense?
Yes. So in the state of Florida, it's a crime to intentionally touch someone against their will. That would include driving off while they're partially out of the car, punching them, hitting them, kicking them. All of those things are a crime against the state of Florida. So the state of Florida has to make a filing decision. As of today, I don't know what they're going to decide. The only reason we're here today is for me to review the probable cause affidavit, determine if there is probable cause, and set bond. So that's what I've done.
Okay, so his bond is $500 because I don't have nothing on me.
You don't have to post his bond, ma'am. He has to.
What do you mean he has to?
It's his bond.
Okay, so how will it get paid?
I'm sorry?
Who can pay it?
Well, anyone can pay it, but he's responsible for it, not you.
Yeah, so it's $500, right?
Yes, ma'am.
10% of $500?
That's between you and a bondsman. I can't tell you what they'll require.
Okay.
Well, between him and a bondsman.
You got no contact, so how will he see his children?
I'm sorry?
How will he see his children?
He can't see them when they're with you because he can't have any contact with you.
Okay, alrighty.
Yes, ma'am. Good luck.
Thank you.
Good morning. Please tell me your name. You're here in 21 MM 8038, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Any other conditions the state would request?
Your Honor, DCF was also notified,
You must comply with any plan set in place by DCF.
as the child was present.
How old is the child?
The child's date of birth is 2020, so approximately a year. Year and a half. May of 2020.
All right, and you can have no unsupervised contact with any minor child under the age of 18. Good luck, sir. Please tell me your name.
Crystal Pacheco.
21 MM 8055. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Just a moment. Your bond in this case is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
There's an allegation of the 9-year-old child being present, DCF being called, and alcohol within this affidavit, Your Honor.
I see that. You must comply with any plan set in place by DCF. You can have no unsupervised contact with any minor child under the age of 18. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. All right, good luck, ma'am.
Okay.
Please tell me your name.
Samuel Shand.
21 8037. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Ma'am, do you wish to testify this morning?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Kayla Bell.
Sir, I need you to look at me or this wall. Don't look at the witness. Go ahead, Miss May.
Good morning, Miss Bell. Can you please state your relationship to Mr. Shend?
Yes, he's my boyfriend of 8 years.
Has anything like this ever happened before?
No.
Are you afraid of him?
No.
Do you believe drugs or alcohol were involved in this incident?
Yes.
Which of the two?
Lots of alcohol.
If anything like this or anything more severe ever occurred in the future and you felt threatened, would you feel comfortable calling 911?
Yes.
And do you want to have contact with him while this case is pending?
Yes, that's fine.
All right. That's all I have, Your Honor.
Anything from the defense?
No questions, Your Honor.
All right, thank you. Thank you, ma'am.
Welcome.
All right, sir, your bond in this case will be $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. Any other conditions the state would request?
No, Your Honor.
All right, good luck. Thank you, ma'am. Good luck.
Yeah.
Please tell me your name. Ma'am,
Caroline Ustry.
you're here in 21 8056, charged with battery, dating violence. At this time, I'll appoint an attorney to represent you. There is probable cause.
I don't think there's a.
Sir, did you wish to testify?
Yes.
Please raise your right hand to be sworn. You look at me or this wall. Do you understand?
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Nicholas Freeman.
Ms. May, do you have questions?
Yes. Good morning, Mr. Freeman. Can you please state your relationship to Miss Ursi? Or Usri, sorry.
My girlfriend of about 3 years.
You mind stepping a little bit closer to the mic?
She is my girlfriend of about 3 years.
Are you afraid of her?
No, not at all.
Has anything like this ever happened before?
No.
If anything like this or anything more severe where you felt threatened ever occurred, would you feel comfortable calling 911?
Yes. Can I explain the situation a little bit?
Once again.
Sir, I can still barely hear you, so I need you to get closer to the microphone.
Is this better?
Sorry, I know, it's because you're really tall.
Is this better?
Yes, thank you.
Okay.
Do you believe drugs or alcohol were involved in this incident?
Yes, she had been drinking and there was just... Am I allowed to explain the situation?
Let me ask a few more questions and I'll ask if you want to tell the court anything. And do you want to have contact with her while this case is pending?
Yes, please.
Anything else you'd like to tell the court?
Yes. So we were at the festival in town last night. She had been drinking. She had too much. We had to go to medical, but she was saying the whole time.
She had too much what?
Too much to drink. But sorry. We were in medical. She kept saying that she never wanted to go and get the medical assistance in the first place, but they kind of forcefully took her there to help her. And then we were trying to go home and she went to the bathroom, but they needed her to come out and she wasn't coming out yet. And so they were like, okay, well, if you don't come out now, we're going to get someone to come in. And so they broke into the porta potty that she was in. And she was half undressed at the time. So I stepped in between, the nurses and her to kind of shield her so she could cover herself. And she thought that I was the one that had told them to go into the porta potty. And so she was obviously, understandably, very upset by that. And so she slapped me, but it was understandable. And I told the officer then that I didn't want to press charges. And I told him that this was not necessary. and that this was an isolated incident, and nothing like this has happened, and I didn't want her to be charged with anything, and just that it wasn't necessary.
All right, thank you, sir. According to the affidavit, she also committed a felony, which is a battery on the medical staff. However, they didn't charge her with that. So,
Your Honor, due to the victim's testimony, the state has no objection to a no hostile.
all right.
What does that mean?
So the state is saying they wouldn't object if I order that she's allowed to have contact with you, but it has to be peaceful.
Yes, of course.
All right, at this time, ma'am, your bond is $500 with special conditions. You can have only peaceful contact with the victim. Do you understand what that means?
Yes, of course.
No yelling, no pushing, no shoving, no hitting. You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any alcoholic beverage or any controlled substance without a valid prescription. You'll be subject to random drug and alcohol screens while out on bond. Good luck, ma'am. Thank you for coming. 500. Good luck, sir.
Okay, and I can bail her out?
I'm sorry?
I can post her bail, correct?
You can. I can't require you to, but you can.
Yes, I know you can. Okay, thank you.
Please tell me your name.
Joshua.
What's your full name, sir?
John L. Cook.
Sir, you're here for a warrant out of Seminole County for a petty theft in 204119 The bond authorized on that warrant is $2,000. We'll notify them that you're here, but you have a bond, so you can post it here if you're able to. And in the meantime, I'll appoint an attorney to represent you. Good luck, sir.
Your Honor, Ms. Jenkins, here's bond.
Good morning, ma'am. Can you tell me your name?
Maylene Marie Grievous.
Good morning, Ms. Grievous. You're here in case 21MM8042, charged with trespass on property after warning. At this time, I'm going to appoint an attorney to represent you. Ma'am, you have to leave your mask on. You can't take it off. All right. There is probable cause for this charge, ma'am. Your bond is $500. You can't return to the Lynx bus. Do you have the address?
Lynx bus station located at 455 North Garland.
You can't go back to that bus station, ma'am. Do you understand? All right, thank you. Miss George, if you can just make some notes.
Yeah, sure.
Have a nice day, ma'am. Good luck. Please tell me your name, ma'am.
Janine Marie Scaglione.
21MM5285. You're here because a capias was issued for your arrest for failing to appear on charges of trespass on property other than a structure or conveyance. The bond on that capias is $1,500.
Your Honor, state did convey an offer of an adjudication, credit time served, and no return to 2239 North Cimarron Boulevard.
I don't know if I'll accept that, but possibly.
And Your Honor, I did speak to Ms. Scallion. We went over all the rights she would be given up. She understands those rights and would like to accept the state's offer here today.
I don't know that I'm inclined to accept that. I see that her last conviction was September 10th of this year for battery on a licensed security officer. So I need more information about this trespass before I can tell you if I'll accept that plea.
Yes, Your Honor. The underlying trespass was at a Wawa at that location. It was approximately at 1 a.m. on August 1st, 2021. The victim informed the defendant was back on the property after being trespassed at 8:50 the earlier day. The law enforcement contacted the defendant, and she said she only returned to use the phone and was arrested without incident.
Give me one moment.
See,
I don't have that.
She was deemed incapacitated in 2021, but it looks like she pled to a battery. So, Your Honor, that may be the issue because I didn't see that one. I'm gonna just.
Okay, hold on.
I mean, she also pled to a possession of meth in August.
Yeah, that's
That,
what.
that bat security officer in September.
I mean, when I spoke to her, I did not have any.
Yeah, and this case predates those two.
Yeah.
All right, ma'am, raise your right hand to be sworn.
Please swear to tell the truth, whole truth, nothing but the truth, so help you God.
Yes, I do.
All right, you had the chance to speak with an attorney before, your attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am, I do.
You can keep your hand down. Do you have any questions for me about those rights?
No, ma'am, I don't.
Did you have the opportunity to review the plea agreement?
Oh, yes, I did.
That further explains those rights to you. You don't have any questions about that?
No, ma'am.
You understand if you're not a U.S. citizen, you can be deported?
Yes.
Do you understand that if you're on probation anywhere, this plea could violate that?
Yes, I am.
All right, ma'am, at this time, how do you wish to plead to the charge of trespass on property other than a structure or conveyance?
No content?
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
43 days.
43 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those.
Can I get
You're
on
not
a
allowed to
payment
return.
plan?
I'm sorry?
Can I get on a payment plan? Can I do a payment plan with them?
You can.
Oh, okay. All right.
But isn't there a new process for that?
I'm not sure of it.
Hold on one second. What's the new process? There's a new process for that. Ms. George, you might need to look into that. There's a new process for payment plans.
Okay.
It's fine. That's fine. I'll pay it.
Well, I just want to make sure, you have a whole year,
Okay.
but you can pay it, $30 a month or something like that.
Okay.
But I know that there's a new process, but because we're out here.
I didn't hear about it. Yes, sir.
Right. Okay. So I'm giving you a year.
Yes, ma'am.
I'm not going to put you on a payment plan this morning, but you can get on a payment plan. That's fine.
Yes, ma'am.
And you have 30 days to appeal in writing. Do you understand?
Yes, ma'am.
Good luck, ma'am.
Thank you.
I don't know what to do because they're supposed to get some paperwork from the clerk.
Yes, Your Honor.
We don't have that. Please tell me your name, sir. Are you Mr. Cruz?
It looks like being responsible for something I took care of, and I just threw a stick to the side of the street because it had a point, like a gun that I didn't have. And
All right, are you Mr. Cruz?
yeah, I'm Cruz Fernando. I took
Okay.
care of something important because I was in a way being bothered, and we know we all got to behave, but some don't like to do that.
So this is
You
2020.
can pay me whatever you want because I didn't strangle a lady or one third. You could get me out of here.
No, Mr. Cruz, that's not why you're here today.
Because
Mr. Cruz,
why are we here? 'Cause I think-
so you're here in 2020 MM 7297 because it looks like you failed to appear for a court date on a charge of criminal mischief.
No, I went to that court date.
Okay, well, the judge thinks that you didn't.
No, I did go last to that court date. Where I think she also said go to a clinical date. But she indicated in the clinical date Wednesday, and it wasn't correct the way she wrote it. That's what we understood.
So this is in front of Judge Steve Jewett.
Yeah.
The bond he authorized is $2,000. I'm going to appoint an attorney to represent you, and they'll talk to the judge.
Because you're going step by step.
What don't you understand?
Right, because, yeah, that's what she wants you to give me to the reason why you brought me here, because I think she understood that I went to court, right, and then they gave me remember that on a Wednesday, she gave me an appointment for a clinical date, but she wrote May, and on May 12th, but it was something like the 13th that I was supposed to be there. That's why you didn't get that correct.
Well, your memory might be better than mine, sir, because I don't remember that date.
Yeah, since I don't really have a judicial record that's extremely bad, you know. I'm just gonna plead for anything I can get, like 33 to 3 days, because that's what it looks like, you know.
So you can't do that today, but on that green piece of paper is a phone number for you to call your attorney, and I need you to do that right away, okay?
Who's the attorney?
Who's his attorney? Does anyone know?
His PD is Samantha Lambert.
So call that number and ask to speak with Samantha Lambert.
Oh, Lambert, I remember her now.
Okay, ask to speak to her.
Yeah.
Great.
You can get me out of here the best you can, because, you know.
I can't, but maybe
favoring
she can.
crookeds, like really yet they are, or favoring really wrong is not me.
Okay, call Miss Lambert. Okay, good luck, sir. Ms. George?
Yes, Your Honor.
I assume you're making notes.
Yes, Your Honor.
I believe there was already a suggestion of incompetence within that case
I
file.
think that's what he was talking about. And I think when he was saying she, he meant his attorney.
And clinical date was potentially that competency.
Right. Because it wasn't the judge. Good morning. Please tell me your name.
Denise Sturgis.
You're here in 21 MO 1319, charged with violating state misdemeanors. There is probable cause here.
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold, credit time served, and no return.
Your Honor.
Was the one in August at the same location?
I can double check, Your Honor.
Okay.
Your Honor, she would like to accept the state's offer here today and plead no contest. She understands the right she would be given if she accepts the state's offer here today.
I'm a little bit concerned about that because I show that her last conviction was in August of this year for the same charge. And based on the affidavit, I'm wondering if it's the same location. Ms. May was going to look at that for me.
I think it's a bus station.
It is.
The one that she pled to in August, 21 MO 936, was a date of incident of August 13th. No, Your Honor, it wasn't a trespass-related state misdemeanors. She allegedly had a knife. And then she took flight from law enforcement. It was arguably like an assault state misdemeanor, Your Honor.
All right.
I see most of her history being city ordinance cases. She has a 2020 open container. I believe it's just potentially a mental health issue.
All right, Ms. Sturgis, raise your right hand, please.
Yes, I do.
All right, there is probable cause here, ma'am. You had the opportunity to speak with an attorney. You can put your hand down. about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, I do.
Do you have any questions for me about them?
No, I don't.
Did you have a chance to review that plea agreement?
Yes.
All right. Do you have any questions about that? It further explains those rights to you.
No, I'm got a question.
You understand that if you're on probation anywhere, this plea could violate it.
Yes.
If you're not a U.S. citizen, you could be deported.
Yes.
All right. At this time, how do you wish to plead to violating state misdemeanors?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. And you're not allowed to return to the Lynx bus station.
Okay. I know.
You also can't possess or consume alcoholic beverages.
Okay. I agree to that. I agree to that.
All right, ma'am. Good luck. You have 30 days to appeal in writing.
Rico Lopez, Bonda, Your Honor.
Okay.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good morning. If you could please connect with the headset.
Certainly, Your Honor. Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Good morning, sir. Please tell me your name.
Eric Serrano Rodriguez. Eric Serrano Rodriguez.
Eric Serrano Rodriguez.
Sir, you have 4 cases here today. 21 CT 7527, 7528, 7529, and 7530. You're here charged with no valid driver's license, no motorcycle license, no motor vehicle registration, and reckless driving. There is probable cause.
Your Honor, he does qualify for pretrial release. Given that he has no criminal history, I would ask for pretrial release.
I'll appoint your office, Ms. George.
Sorry.
What says the state?
Your Honor, state has no objection, but we potentially ask for bond with pretrial release. Employment also, it looks like being driving related. Looks like it does delivery for Home Depot.
Yeah, that's really concerning to the court because of the facts in the affidavit.
I understand that, Your Honor. However, again, he has history. He'll be monitored by pretrial release. I don't think that a monetary bond in his case is necessary.
It does appear he potentially be going back to Pennsylvania as well, Your Honor.
That is what it says. At this time, I'm going to place you on pretrial release and require that you post a monetary bond in 7530 of $500.
Is that the reckless, Your Honor?
It is. You can have no contact with any witness or co-defendant in this case. You can't drive in Florida. Are there any other conditions the state would request?
Your Honor.
Good luck, sir.
Thank you.
The same. Just no, I'm not requiring monetary bond, just PTR in those. So the $500 is on the reckless. Everything else is straight PTR.
Is it straight 500?
And pretrial release on the reckless. Yes. Please tell me your name.
Melvin Manuel Vargas Martinez. Melvin Manuel Vargas Martinez.
Melvin Manuel Vargas Martinez.
Sí.
Yes.
You're here in several cases, 21 CT 7533, 7534, 7535, and 21 MM 8052. You're charged with no motor vehicle registration, reckless driving, no motorcycle license, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you in each of these cases.
Your Honor, I would ask for pretrial release. In this case, it's different from last case in that I believe he has a driver's license, he just does not have a
Sorry,
motorcycle.
Counsel, if you could kindly approach your microphone, you're breaking up.
Sorry. In this case, I believe he has a driver's license, just not a motorcycle license.
Sí.
Yes.
So I'd ask for straight pretrial release in this case.
But Counselor, he's also here on vacation.
I thought the
So-
only reason you gave it was because of the license issue, Your Honor.
No, it's because they're not
Okay.
here, and one of the purposes is just to secure their presence for future court dates.
Yes.
So that's one of the things that concerns the court, is he's not from this area. He may not come back.
Okay, I understand, Your Honor.
Sorry, perhaps I should have put that on the record. All right, in all of these cases, I'll place him on pretrial release. In the reckless driving, 7534, your bond will be $500 with pretrial release. With special conditions, you can have no contact with any witness or co-defendant in this case. You can't drive in the state of Florida right now. You can't return to this area for any reason. Do you understand that?
Sí.
Yes.
All right, good luck.
Pero otra pregunta, una pregunta. No puedo
I do have a
conducir
question.
moto o carro.
So
Yes, sir.
I'm not allowed to drive motorcycles or cars?
Cars or motorcycles in the state of Florida right now. Nothing. Don't drive.
¿Está bien?
That's fine.
All right, good luck, sir.
Gracias.
Thank you.
Please tell me your name.
Wilmar Marvin González González.
Wilmar Marvin González González.
21 CF 14734. Sir, you're here charged with possession of a drug. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor. I would argue no PC to the drug possession. If you look at the arrest affidavit, the officer never tested the white substance. In order for the state to prove possession of a controlled substance, the state must prove that the defendant possessed the substance, and they must state the exact substance that the defendant had. Here, the officer never tested, nor did my client admit to having a substance. So I would argue no PC.
So I read the affidavit, and it says that, I'm trying to find where he said it. He said, based on my training and experience, the substance has an appearance of the commonly known narcotic substance of fentanyl, which is known to be a hazardous which is known as a hazardous fatal drug. The white powdery glassy substance was not field tested on scene, but will be sent to FDLE testing. So is there any case law that says there has to be a field test before probable cause can be found?
No, Your Honor. I mean, I haven't seen any cases that deal with probable cause in a substance.
Because I agree with you, for the state to prove it, they will have to have a chemical test. And in fact, we've had this discussion multiple times that the field test isn't sufficient. But today we're just looking at probable cause.
Correct, Your Honor. And normally we have the field test, although not admissible, we don't have it here today. We don't have a field test to show that it is in fact a narcotic. In other cases, we've seen where the defendant either admits to what the substance is, so the officer doesn't test it. Here we have the officer looking at the item and stating that it looks like fentanyl, but we don't know if he was in actual possession of any drug. So I would argue no PC, given that we don't have that field test to show that he was in actual constructive possession of a synthetic substance.
So the officer's observation is insufficient for probable cause?
Your Honor, again, probable cause, I haven't seen any case law dealing with probable cause for the most part. When I've tried to research it, all we have is, again, the case law, the statute says he must be in actual possession of a substance. I don't have the actual possession of a substance based on this arrest affidavit, given that it was not field tested.
Okay, hold on. Let's pull out the statute. And what says the state?
Your Honor, you made multiple arguments that the state was going to make.
I didn't make any arguments. I'm just asking questions.
But you've pointed to a lot of the arguments the state was going to make. In regards to what counsel's arguing, that we have to prove that it was a substance for conviction. Probable cause, we have to just show that it's more likely than not he possessed some substance. State will contend that his training and experience, coupled with that it is a high potency narcotic, and I believe it's agency policy not to test it due to being a high potency narcotic. As this came out of Highway Patrol, this didn't come out of OPD or OCSO. And due to just being hazardous and high potency, I believe it's agency policy not to test it. Let's pretend that the officer's training and experience, that the substance has the appearance of the known narcotic of fentanyl. He described it as a white, powdery, crystal-like substance multiple times throughout the affidavit. And at this point, we just prove more likely than not he can be in possession of some substance. So they would argue that there is enough. I don't know of any other case law either regarding field testing positive, or having to have that for probable cause, as it is otherwise in the municipal court. It would only be beneficial for the officer on scene, whether or not they wanted to make an arrest. And I guess it would aid in the PC determination. I don't know if it is 100% necessary for them to make that PC determination.
And even if, Your Honor, you decide to find PC in this case, given that the substance was not tested, and he has not been arrested for drugs before, I would ask for an ROR because we don't know if it was a substance or not. And my client is going to have to pay a bond on something that we have no idea if it was a substance, if it wasn't. And just in all fairness, I would ask for an ROR in this case, Your Honor. Nonviolent offense. All we know is it's a substance the officer believes is fentanyl. So if you find PC, I would ask for an ROR. It appears he lives in Mount Dora, so he is in Florida. And he has no convictions, just arrests, which are also nonviolent.
I do believe he potentially has a warrant or another detainer coming soon. And
For what?
its only concern is his potential community ties, as there was an alien inadmissibility issue earlier.
He is employed, Your Honor. He's been employed for 7 years at this one employment, Denton Lawn Services. And again, it shows he's lived here in Mount Dora for over a year, which is in Florida, not necessarily in Orange County, but he's in Florida. He's not out of state. So I just ask that you take all of that into consideration and the facts of this arrest affidavit.
All right, thank you. I appreciate all of that from both of you. I'll tell you what I'm thinking. So I pulled out the statute, 893.13. Except as authorized by this chapter, a person may not sell, manufacture, or deliver, or possess with intent to sell. Wait, no, sorry. Hold on, let me get the right one. No, that is what it says. Interesting. Hold on. I think it would be. Where's the straight possession, Miss May?
Sorry?
Where's the straight possession?
Statute?
Yes. I'm looking at it in my book. And 3, 6. Or Miss May, if you have it.
Or you can.
Here it is. A person, I'm sorry, I meant Miss Georgia. A person may not be in actual or constructive possession of a controlled substance unless it was lawfully obtained from a practitioner pursuant to a valid prescription. A person may not be in actual or constructive possession. Where does it say in the statute that he has to know what the substance is?
Of a controlled substance is
Right.
key. We don't know what this substance is. It could be flour, it could be anything.
Right, but I'm just looking for in the statute.
Oh, I look at the statute and then I go for more
Looking at the
information
jury
to the jury
instructions?
instructions. Correct, Your Honor.
Because this just says a person may not be in actual or constructive possession of a controlled substance unless they have a valid prescription.
Right.
It doesn't say they have to know. However, in the affidavit, the reason law enforcement arrives is to investigate the single crash where the allegation is your client crashed his vehicle into a fence and then was attempting to conceal something, which was later found to be the plastic baggie that had the substance in it. So if it was flour, I can't imagine why you would want to conceal that from law enforcement.
Correct, Your Honor. However, we're assuming I don't know what the substance was. That's why the statute says he must be in possession of the substance.
Right,
um,
a controlled
a
substance.
controlled substance. My argument is,
Mm.
we don't know what that
But
controlled
it's not.
substance is. And because we don't know, I would argue no PC, because we don't know if he was actually, in fact, in possession of that controlled substance.
Your Honor,
It's a great argument, Ms. George. It really is.
the state's only argument is that the officer's training and experience would be enough for PC purposes, that it was a controlled substance at this time. It wouldn't be enough for a conviction or to support the charge. But training experience, as well as a description, as well as the defense demeanor.
Let's compare it to a different substance. Let's say that he was in possession of what appears to be a firearm, right? Law enforcement sees it, and they say in their affidavit usually appears to be, you know, that it's able to release a projectile, blah, 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 right? There's all of those things. But law enforcement doesn't shoot the gun at the scene, right? They find something that looks like a gun, that's probable cause, they make the arrest, and then for the state to sustain a conviction, they're going to have to test fire the gun. Because if it's, for instance, an antique that is incapable of firing a gun, then it wouldn't violate that statute.
Yes, Your Honor, but when you're dealing with the firearm, normally the officer is able to tell what type of firearm it is. They are usually able to tell if it has live rounds in the firearm. So they'll pull it out to see if there's live rounds in the firearm. And that's why in some arrest affidavits, they'll mention that it's a BB gun. Maybe they originally thought it was a gun, but it turned out to be a BB gun.
Okay.
That's still all officer training and experience of determining those items, though, and determining those things.
I think it's a great argument, Ms. George. But I think the totality of the circumstances, especially given the allegation that your client was trying to conceal it, I think it's enough for probable cause. But I'm going to grant your request. To release him on his own recognizance. Mr. Gonzalez, however, while you're released, you can't possess or consume any controlled substance without a valid prescription or any alcoholic beverages. You'll be subject to random drug and alcohol screens. I also don't know why they didn't arrest him for a DUI, but they didn't. All right, good luck, sir. Stay in touch with your attorney. Is that all we have for the interpreter cases? We have one more? Okay.
And Your Honor, my apologies for interrupting. If you could kindly call back and have another one of my colleagues, I'm actually needed somewhere else at the moment.
Okay, thank you.
Thank you.
I missed that. Okay, thank you.
Never had that happen before. That was a great argument, Ms. George. You really made me think.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter, already sworn.
Thank you. If you could please connect with the headset. Sir, can you hear me?
The defendant can hear me, Your Honor.
Please tell me your name.
Luis Zapata.
Luis Zapata.
2010 CT 5030. It looks like you're here for violating your probation. I'm going to appoint an attorney to represent you.
I'll enter a denial, Your Honor.
Division 82, BLP status will be December 14th at 1:30 p.m., courtroom 10B.
Good luck, sir.
Okay.
What's the name of the next interpreter case? Oh, I thought you said there were two more.
That's the last one.
Okay. All right, that's all we need from the interpreter at this time.
Thank you.
Thank you. All right. Yes.
Millen, his medical.
21 CT 6631. Ms. George, I'm going to appoint your office.
I'll waive and enter a plea of not guilty, Your Honor.
Division 81, pretrial conference, December 10th, 9 a.m., courtroom 4E.
Your Honor, can we pass Mr. Briggs and go to Jimmy Legret?
What about William Montanez?
Okay.
I don't have the one that you just said.
Yes, we returned him. He returned
Oh,
him. I didn't know if you were.
okay. That's who I have next. Is a private attorney? Do we know who it is?
Yeah, we need Greg too, but.
Okay. Okay. All right. Good morning. Please tell me your name. You're here in 21 MM 3208, charged with battery, domestic violence, and criminal mischief. At this time, I'm going to appoint an attorney to represent you.
I'll enter a plea of not guilty, Your Honor.
Division 50, pretrial conference will be December 13th, 1:30 p.m., courtroom 7C.
That's your next court date, sir. Good luck. Please tell me your name.
William Montanez.
All right, you have several cases, 20 MM 6876. It's a violation of a domestic violence injunction and violation of pretrial release conditions on a domestic violence case. I think it's a VOP. 2020 MM 5761. It's the same charges, also a violation of probation. And 2020 MM 6875. It's the same charges, also a violation of probation. Ms. George, I'm going to appoint your office in all three cases.
I'll enter a denial. It's a VOP, correct?
I think they're all three VOPs.
Yes, I'll enter denial, Your Honor.
Okay.
Division 50, VOP status will be December 10th, 9 a.m., courtroom 7C.
That's your next court date.
Downtown, right?
It is. So if you're in custody, though, they'll either transport you or it'll be electronic. It'll be virtual.
No bond still, right?
No, it's a VOP.
Okay.
Yes, sir. Good luck.
All right.
21 MM 7931. Your office represents him already, Ms. George?
I'll waive and enter a plea of not guilty, Your Honor.
Division 85, pretrial conference is December 13th, 9 a.m., courtroom 4A.
Sir, please tell me your name.
Ramon Robinson.
You're here in 21 MM 6886, charged with battery. Your office already represents him, Ms. George?
I'll enter a plea of not guilty, Your Honor.
Division 84, pretrial conference is December 13th, 9 a.m., courtroom 4B.
Good luck, sir.
Ms. Gibson, I got one
Yes.
question for you. I was never served an arrest warrant, and they filed charges on September 28th. So normally you're supposed to get arrested before the state files charges, aren't you? That was
Not necessarily. The state can file it, but they would eventually serve you with it, even if you weren't arrested. But I don't have that. Let me pull up do you have the court file?
yeah. I've never had been filed charges on without being arrested first. Like that seems kind of backwards.
No, the state can file charges even if you haven't been arrested. That can happen. But let me look at this and see what happened in this case.
I've been arrested a lot, Ms. Gibson. I don't know.
It does happen because sometimes what will happen is law enforcement will do an investigation and not make a decision to arrest and take it to the state attorney's office. And then the state attorney's office will do an investigation and determine to file charges. I don't know if that's what happened in this case.
Yeah, I'm not sure either, but I've never seen it though.
Ms. May, do you have it?
I would think that would null and void my case, Your Honor.
It doesn't. It's still lawful. The state attorney's office is the charging. That's who's filing the charges. They're separate from law enforcement. Hold on one second.
That information was filed 9/24. A summons was issued 9/28, subject to that information. It was then set for arraignment where he failed to appear. It was reset for arraignment again.
That was last week. They took me over here in here last week. I've been in jail since August 3rd. They didn't know if I was in jail. I don't know why. They kept trying to find me on the street. And Judge Bain last week was like, "Oh, what y'all doing, prosecution?" And prosecution didn't know what was going on. And he's like, "Hey, Mr. Robinson, you're gonna probably come back again," which is today. Sheriff Dragon served me last Thursday this summons.
So then that's why you're here today, is once the summons was issued, it was served on you,
Right.
and then they brought you back to be arraigned on the charges.
Right. It's just that I know they filed on September 28th. I've been in jail since
24th.
August 3rd. I have a few charges, but every charge I got, I've been served a warrant. I've never been served a warrant. In this case, they filed charges at the end of September. I've been arrested since 2006. I've never seen this happen in my life. I'm thinking this null and voids the whole case.
It doesn't. It doesn't. The state did serve you.
After my
Yeah, it was
they
returned to the
filed
state to
charges.
perfect service, yeah.
That's like backwards.
It's not. It's just the way that sometimes the cases go. You are correct. Typically what happens is law enforcement arrests you first and then the state decides, but it doesn't always happen that way. And this is still a lawful way for the state to charge you.
Is it because I'm in jail? Because if I was on the street, would they be able to do it like that too?
Yes, they could still do it that way.
Never seen it.
It's unusual. You're correct. That's not how they usually do it, but it's still lawful. So you got his next court date? Did we already do that?
Yes.
Okay, all right. Get in touch with your attorney, sir, so they know that you've been served and arraigned on this charge.
So it's not a legal search and seizure?
It's not.
All right, we'll check into it, Your Honor. Thank you.
Good luck, sir. Call your attorney. Please tell me your name.
David Vaught.
21MM6727. You're here charged with petty theft. Ms. George, your office already represents him.
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit time served, and no return to Home Depot located at 6130 East Colonial Drive. I did have a chance to speak to Mr. Vaughn. We went over all the rights he would be giving up. He understands those rights and would like to enter a plea of no contest. And I also went over the right that this is an enhanceable offense, Your Honor.
All right, Mr. Vaught, raise your right hand, please.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, you had the chance to speak with your attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
Did you review that plea agreement in front of you?
I have, ma'am.
It further explains those rights to you. Do you have any questions about it?
No, ma'am.
You understand if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
If you're on probation anywhere, this plea could violate that probation. Do you understand? And you understand that petty theft is what we call an enhanceable crime, which means that after so many times, the state can file it as a felony instead of a misdemeanor. So a misdemeanor is punishable by up to 60 days in jail or a year in jail, whether it's a first degree or second degree. A third degree felony, which is what felony petty theft is punishable by up to 5 years in prison. You understand that? I don't know anything about your record, so I don't know if you have any others, but this could qualify as a conviction that would then make it possible for the state to file as a felony. You understand?
Yeah.
Understanding that, how do you wish to plead to the charge of petty theft?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 6 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You're not allowed to return to, did you give him the address?
It was the Home Depot located at 6130 East Colonial Drive.
You understand that, sir?
Ma'am.
All right, good luck, sir. You have 30 days to appeal in writing. Sir, please tell me your name.
Dwayne Woodson.
You're here in 21 MM 7190, charged with petty theft of $100 or more. Ms. George, your office represents him?
An answer a plea of not guilty, Your Honor.
All right. That's you.
Division 61, pretrial conference is January 7th at 1:30 PM, courtroom 6B.
That's your next court date, sir. I know who he is. Do you guys have him next?
We can, Your Honor. We can do them next, sir.
Are you ready, counselor?
Yes, ma'am.
All right. Good morning, counselor.
Morning, Jonathan Rose on behalf of Bernard Peters.
Is this from the felony section?
It is. Sir, can you tell me your name?
Bernard Peters, ma'am.
All right. Mr. Peters, your attorney is here with you. He just put his appearance on record. Let me pull up your case. I can find it. You're here in 21 CF 14720, charged with trafficking in methamphetamines greater than 28 grams with a weapon, possession of cannabis with intent to sell with a weapon, possession of cannabis greater than 20 grams, and possession of drug paraphernalia. At this time, let me ask your attorney, did you wish to be heard on any of those charges, counselor?
In terms of the probable cause, no, Judge.
All right. I agree with that. I reviewed the affidavit. I do think there's probable cause here, but I wanted to give you that opportunity. Did you wish to be heard on bond?
Judge, we request that the court issue a $50,000 bond, which is a bit below bond schedule. I've spoken with his brother. His brother believes that they would be able to meet that amount. Anything else?
I'm sorry. I don't want to interrupt. I'm not trying to interrupt, but did you say 1-5 or 5-0?
5-0.
5-0. I'm sorry. I could not hear that.
There is a mask on my face, and I'm probably not speaking as clearly as I could.
No, it's difficult in the courtroom with the masks, and sometimes the sound is not great in here, so I appreciate your patience.
Yes, ma'am. Thank you.
Go ahead. I'm sorry. His brother said.
His brother indicated to me that the family could afford that level of bond. Anything else would become more problematic, but that much they can afford. And he has, I think, no previous felony convictions, only misdemeanors, if I'm not mistaken. He's 34 years old. He's lived in Central Florida his entire life.
What says the state?
Your Honor, count 1 is a first-degree felony that's punishable by life. At this time, state is asking that you hold him no bond pending an Arthur hearing. He was allegedly in possession of 83.5 grams of the methamphetamine with a weapon. So this time, state's asking for no bond as to count 1 due to being a life offense.
Counselor, I do agree with the state that I believe it's a first-degree felony punishable by up to life in prison. Based on that, I don't believe your client is entitled to bond on that count. As you're, I'm sure, aware, there's a split in the DCAs about whether there's the ability to have basically sort of 2 Arthur hearings.
Yes, ma'am.
And I don't know, hold on, let me see which judge you have. I don't know how Judge Calderon interprets that.
Yes, ma'am.
So I'll tell you that I'm inclined to hold him at no bond on count 1 because it's a PBO. If you want to have an Arthur hearing today, we can do that, and then you can decide, you can ask Judge Calderon if he'll have a second one, but I don't know that he will.
Right. I understand the conundrum there. May I confer very briefly?
Yes, yes. And if you need to step out of the courtroom, I'll give you 5 minutes to talk to him, because I understand it's a big decision, and I want to make sure he has the opportunity to hear from you.
Yes, ma'am.
Can you guys take them out? Okay. Just give him 5 minutes to talk. I can keep going. We'll recall it.
Mr. Cody Randall, mental health.
21 MM 550. Ms. George, I'll appoint your office.
We'll see if we can try tomorrow, Your Honor. There was an offer.
All right, I'll reset him for tomorrow. Good morning, sir. Please tell me your name.
Jason Howard.
Mr. Howard, you're here in 21 MM 8057, charged with possession of a prescription drug without a prescription. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500. Sir, you can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You also can't possess a weapon of any kind, firearm or ammunition. And at this time, it looks like you have a violation of probation out of Sarasota County, 1907483. We'll notify them that you're here. You'll have no bond on that. And in the meantime, I'll appoint an attorney from here to represent you. Good luck, sir.
Mr. Maldonado, counter refused.
21 MM 8044. I'll find his refusal a willing waiver of his appearance today. Ms. George, I'm going to appoint your office.
Okay, Your Honor.
There is probable cause.
Your Honor, I know he refused. I would ask to reset it for tomorrow. He does have an offer to resolve his case. I believe he is a military veteran, and I know he was, I believe, taking money from vehicles. So I just asked that we allow him to see if he would come tomorrow to resolve his case. On his out on bond, they filed a notice of non-filing, so I wanted to see if he wanted to resolve the soliciting charges.
I was inclined to revoke his out on bond.
Yes. I was gonna ask you not, given that the state has not filed on it. He was released on a 33-day motion.
I'll reset it for tomorrow.
Okay.
Please tell me your name.
Mbuta Elvis. Mbuta Elvis.
21 MM 8041. You're here charged with criminal mischief, damage less than $200 or equal to $200. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $250 with special conditions. You can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. Is this where you live? Did this happen where you live?
Yes, Your Honor.
I'm going to order that you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. At this time, I'm revoking your out on bond case.
Your Honor.
Yes, sir. Before you say anything, let me just make sure you understand that everything you say here is being recorded and can be used against you later. Do you understand?
Yes, ma'am.
Let me just give you a moment to talk to your attorney before you say anything else.
Your Honor, for the affidavit, I don't believe the victim and the defendant knew each other. Allegedly, the defendant knocked on the door. The victim would not answer it. The defendant was looking apparently for his girlfriend.
Okay, so he doesn't live there.
I don't believe he lives there.
I was confused by that, but when I asked him, he said he does. He must have been confused by my question then.
And then,
So I'm gonna
yes,
strike that.
I believe he was looking for his girlfriend at that apartment for whatever reason. Just they would ask for no return instead.
That's what I'm gonna do. I'm sorry, Miss Arlene. I'm striking the maintain separate and one return and putting no return to the scene.
State, do you have an offer to resolve the criminal mischief?
No, due to it being a victim crime.
I just told you. They're not gonna resolve it. It's a victim.
Yeah. I had a job interview tomorrow, ma'am.
I'm sorry?
I had a job interview tomorrow, and I leave. That's where I live, and there's actually not a victim. I was the victim.
So listen, sir, I'm not telling you that everything that's in this affidavit is true and accurate.
Yes, Your Honor.
It's all I have to go on. So this hearing is just to determine probable cause.
Okay.
I don't know that the state's even going to file these charges. They may determine they're not going to. But today,
Yes,
all I have is the arrest affidavit, so there is probable cause. I'm not saying you're guilty.
So I couldn't solve it today.
Right, I have no, you can't, because it's a victim crime and the state won't give you an offer until they speak to the victim. The victim has a right to be here at any court date where we're doing anything significant. So you can't resolve it today. I'm changing my order, my previous order, to say that you're not allowed to return to the scene. And you can't have contact with the victim. You understand that?
Yes, ma'am.
All right, good luck, sir. Call your attorney right away.
Call the behavior, Your Honor.
21 MM 8050. Mr. Ward, I'll appoint your office.
I'm gonna waive the appearance, Your Honor,
Oh,
because we weren't gonna accept the offer anyway.
okay. There is probable cause.
I would ask for, since he has no criminal history, I would ask for a $250 bond, Your Honor.
What says the state?
State has no objection, Your Honor.
All right, I'll set the bond at $250. He's not allowed to return to the scene for any reason. Please tell me your name.
Raven Leon Schaefer.
21 MM 8051. You're here charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor. The offer from the state was an adjudication of guilt, credit time served, and no return to racetrack. I don't have the address, Miss. I did have a chance to speak to Mr. Schaefer. We went over all the rights we'll be giving up. He understands those rights and would like to accept the state's offer here today.
All right, Mr. Schaefer, I need you to raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, you can put your hand down now. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about those rights?
No, ma'am.
Did you have a chance to review that plea form in front of you?
Yes, ma'am.
It further explains those rights to you. Do you have any questions about it?
No, ma'am.
You understand that if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right, sir. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You're not allowed to return. Did we get the address?
Yes, Your Honor. So the racetrack located at 14751 East Colonial Drive.
All right, you can't go back there. You understand? All right, sir. Good luck. You have 30 days to appeal in writing. Thank you. Do we have,
Mr. Peters or Mr. Ware?
are we ready?
Yes, ma'am.
All right, we can come back to your case. Mr. Rhodes, this is Mr. Peters, 21 CF 14720. Did you have an opportunity to discuss with your client and what you want to do today?
Yes, Your Honor. Mr. Peters is aware that if we go forward with the Arthur hearing today, we may or may not be able to relitigate the issue with Judge Calderon at the trial level, understanding that he would like to go forward with his Arthur hearing at this moment.
All right. Ms. May, does the state need, do we need to do this at the end of the docket? Do you need time?
No, Your Honor, I'm not going to call witnesses. I'm going to rely on the four corners of the affidavit due to it being a drug case, not a victim case.
All right. Go ahead, Mr. Rhodes.
Your Honor, I would note that obviously the standard for an Arthur hearing is that the state, in this case, the four corners of the affidavit, would have to present evidence that he is guilty of these two trafficking charges with evidence that is proof, evident, presumption great, the highest legal standard in the state of Florida. This is really nothing more than a constructive possession case. The two drugs containers of drugs, bags, whatever they were both on the passenger side of the car. This is a jointly occupied vehicle. He was not even actually in the vehicle at the time of the arrest. The officer said that he looked like he was getting into the car, but he never actually got into the car. There's no evidence whatsoever connecting Mr. Peters to the two bags that are at issue, whether it's the cannabis or it's the methamphetamine. He made a number of statements, but none of those statements were inculpatory in the sense that he said, I knew that it was there. There's no furtive movement. There is nothing of that nature. There's no indication of DNA or fingerprints or anything of that nature. Given that this is a constructive possession case and the state's, this affidavit would have to show with proof evident, presumption great, that he knew that those items were there on the passenger floorboard, therefore not in his plain view, that he knew they were there and he had the ability to control them. There is no evidence of that. The only evidence in this case that he would have known that they were there or would suggest that he would have known that they were there is the statement, alleged statement of this person who was in the car with him. And I would suggest to the court that it was on these items were on his side of the car, on the passenger side, in the floorboard. What is the man going to say? He's going to say that they're not his. There's no other rational thing for the man to say. He's not going to tell the police, yeah, oh no, don't bother him, that those 25-year minimum mandatory amounts of drugs are mine. So given the nature of that statement and the convenience of that statement for the person making it, there literally is nothing. And he doesn't say that they belong to him. He's guessing that they belong to him. That's the language of it is this, like, I believe they belong to him. He doesn't say, yeah, they were in the car when I got there and I saw them and he said that they were his, or he threw them in the floorboard. There's none of that. He's speculating when he says, I believe they're his. So there is no evidence that connects him to those. There is speculation. There are what the police believe to be some inconsistent statements, but we're not talking about probable cause at this moment. We're talking about proof, evident, presumption great, the highest legal standard in the state of Florida. Therefore, given the legal standard and given the dearth of evidence in this affidavit that he was aware of or able to control the items that are in the passenger side floorboard, and he was outside the car on the driver's side, completely out of his line of view, out of plain view, there is no evidence, certainly not evidence that is required in an Arthur hearing to deny him bond.
All right, thank you. What says the state?
Yes, Your Honor. In regards to counsel's first argument, constructive possession can still be enough for possession and prove evident presumption great. In this instant case, the defendant had the keys to the car in his pocket. He had the firearm on his person. He also had approximately, I believe, about 10 grams of cannabis on his person in two separate bags, which were the only other drugs found. In addition, the law enforcement officer, when he arrived, stated that the co-defendant, the passenger, his demeanor was calm as opposed to the defendant, who was extremely confrontational and nervous, just pointing to the defendant's knowledge that the drugs were potentially within the vehicle, as well as the firearm and the other cannabis that was on his person. In addition to that, the defendant's wallet was on the driver's side floorboard. And the car was also registered, according to the defendant, was first, he said it was belonging to his baby mama, Miss Williams. And then he later said it belonged to Mr. Dwayne Scott. The story that the defendant gave was inconsistent the entire time. He goes into the story about regarding the Dodge Ram. Then we speak to the law enforcement officer spoke to the passenger, who completely contradicted the defendant's story. And upon arrest, the defendant said, are they towing his car? inferring that it was his, therefore he would have knowledge of what was within his vehicle and would have the ability to exercise dominion and control over his vehicle. And then regarding counsel's argument that the passenger floorboard would not be in plain view, I think is not necessarily true. You can see into the passenger floorboard standing outside the vehicle or sitting within the driver's seat. So they arguably would be in plain view from the driver's seat as well as standing inside the driver's side door, which is, I believe, how law enforcement originally found the defendant.
Judge, may I be heard briefly?
Yes, please.
So, Judge, in order to establish proof evident presumption great, the state has to rely on the contents of the affidavit in this case. I understand the state's point about the plain view issue. Maybe you could, maybe you couldn't. The point is that there is no evidence in this affidavit that he would have known it's there. This is a constructive possession issue. In a jointly occupied vehicle, there's got to be independent evidence that shows that someone was able to control it and that it was there, regardless of who the vehicle is registered to. That's really not a factor here. The issue is that there's very little evidence, or no and very little evidence that he knew or had the ability to control those two bags. They were on the passenger side. There was zero evidence that suggests that the passenger didn't take those out of his pocket and throw them in the floor. That's the whole issue with constructive possession. You have to be able to prove that the person knew that they were there and had the ability to control them. And in this case, of course, this is not a probable cause determination. This is determination that there is proof evident presumption great. So given all of those factors, I certainly think that the court should make a finding that there is not proof evident presumption great of the possession of those. And I would also add that he was not charged with a gun offense per se because he had a concealed carry permit.
All right, thank you. I reviewed the statute earlier because we just had we had another drug case, so I just read that statute, but I'm going back to look at the jury instructions really quickly just for information. Assessed. Knew of the existence and intentionally exercised control over that substance. So I'm looking at the jury instruction as it defines possession, joint possession. And as you stated, counsel, the state has to prove that if in possession that The defendant intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Control can be established by proof that defendant had direct personal power to control the substance or the present ability to direct its control by another. And then, of course, there's joint possession. In this case, the affidavit alleges that your client had the keys to the Audi in his pocket. He also had cannabis in his pocket. He opened the driver's door, but then did not sit in the Audi. And that he repeatedly said to law enforcement, he asked if I towed his car, referring to the Audi. The drugs are found in the passenger floorboard. The affidavit does not say anything about them being under the seat, or it says they're on the passenger floorboard, which is where your feet would be if you were the passenger.
Right.
So I think there's no question the passenger also possessed the narcotics. It says that a black digital scale was located in the center console. Your client's wallet was located on the driver's side floorboard. As the state said, your client told law enforcement that the car belonged to first his baby mama, Nicole Williams. Then he said it belonged to Dwayne Scott. Which is relevant to the court because he's the one with the keys to the vehicle, exercising control over it, and telling law enforcement who owns the vehicle, right? So we're not talking about who rightfully does. I don't know who actually owns it. So he has a gun in his pocket. He has cannabis in his pocket. And then there's cannabis found on the floorboard of the car to which he has the keys. I don't suppose you have any case law that's instructive on this, counselor, by chance?
I could research some very quickly. If I can get an internet signal.
Do you want to, I'm sorry to do this, but can we pass this one more time and bring him back?
Of course.
And give the attorneys a few moments to research. I know, Ms. May, you're still in here with me, but.
I'm not able to research anything, Your Honor, because I have to.
All right, well, let's see if he gets any case law, and then I'll give you moments to review his case law and research. We'll bring you back, Mr. Peters. Thank you for your patience.
Your Honor, did we mention Mr. Ware was mental health?
No, that's 21 MM 8046. I'll appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
Okay. There is probable cause. Bond is $500. No return. No contact with any victim or witness. I did. Sir, please tell me your name.
Cyrus Lamar Brown.
Mr. Brown, you're here in 21 MO 1318, charged with disorderly conduct. Was there an offer in this case?
Yes, Your Honor. The offer from the state was a withhold of adjudication, credit time served, and court costs, Your Honor. I did speak to Mr. Brown. We went over all the rights would be given up. He understands those rights and would like to accept the state's offer.
Mr. Brown, I need you to raise your right hand, please.
You swear to tell the truth, whole truth, nothing but the truth, so help you God?
All right, Mr. Brown, you can put your hand down now. You heard what Ms. George just said, and you had the opportunity to speak with her before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about those rights? Sir, you understand that if you're not a U.S. citizen, this plea could cause you to be deported. And if you're on probation anywhere, this plea could violate that. I reviewed the affidavit. There is probable cause. At this time, sir, how do you wish to plead to the charge of disorderly conduct? I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs, and I'll give you a year to pay those. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name. Oh.
Jesus Diaz.
You're here in 21 CT 7522, 7523, and 7524, charged with no motor vehicle registration, no motorcycle license, and reckless driving.
I was asking to see, I see he was, his ties were verified. I was trying to see, could he qualify? Okay. Your Honor, so I would just ask for pretrial release and the $500 bond like you did on the other cases for the reckless driving.
I'll appoint your office. What says the state?
Your Honor, state has no objection.
This one's a little bit different. Ms. George, your client had drugs on him as well.
Your Honor, I would just argue that the officer did not charge him with drugs. Also that he has no criminal history here, and he's actually not out of state. It appears he lives in Florida.
Your Honor, state's only concern is he also arguably there's a resisting officer without violence. He attempted to flee the traffic stop as well.
He absolutely did.
And I think on the other one, he had a resisting as well, and we still gave him pretrial release and a $500 bond, Your Honor.
This is a fleeing or attempting to elude. I don't know why they didn't arrest it as that, but that's clearly what's in this affidavit. All right, sir, I'm going to place you on pretrial release in all 3 cases. In the reckless driving case, you'll have a $500 bond as well. You can have no contact with any witness or co-defendant in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens. You can't return to this area for any reason. You can't drive in the state of Florida right now. Do you understand?
Yes, Your Honor.
All right, good luck, sir.
Thank you.
Those cases are ridiculously dangerous.
Yes, Your Honor, I understand.
It's a miracle there's not a death there. Please tell me your name.
Jonathan Stacy Maddox.
Sir, you're here in 2 cases. In 21 CT 7143, a capias was issued for your arrest for failing to appear for charges of driving while license suspended or revoked with knowledge. The bond authorized on that capias is $500. I'll appoint an attorney to represent you. Then in 21 CT 7525, nope, that's not right. Hold on a minute. That's right. Oh, sorry, I was looking at the wrong one. That's right, 7525. You're here charged with driving while license suspended or revoked with knowledge. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500. You can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
Good luck, sir.
Your Honor, David Mason, bond.
All right. I don't. Please tell me your name.
Sullivan.
21 CT 7531. You're here charged with no valid driver's license. There is probable cause. Your bond is $500. You can't drive without a valid Florida license. Do you understand?
Yes, ma'am. From my understanding, I was also told that I was charged with violation of probation. I cannot find out.
You do have 2 VOPs out of St. Johns County for, it looks like, retail theft in 1900551 and 1900540. We'll notify them that you're here, but you do not have bond on those charges. And in the meantime, I'll appoint an attorney here to represent you. Yes, ma'am. Good luck. Please tell me your name.
Priscilla Torres.
21 CT 7532. You're here charged with driving under the influence.
Yes.
I'm going to appoint an attorney to represent you in this case.
Okay.
There is probable cause here. Your bond is $500.
Okay.
You can't possess or consume any alcoholic beverage or any controlled substance without a valid prescription. You'll be subject to random drug and alcohol screens.
Okay.
You can't drive without a valid Florida license. Any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. Please tell me your name.
Rupert L. Watson.
Mr. Watson, you're here in 21 CT 7536, charged with driving under the influence with a balance greater than 0.2.
Oh, I was never driving.
Don't talk about
Sorry.
that.
I'm going to appoint an attorney to represent you. Sir, everything you say here is being recorded and can be used against you later. Do you understand that?
I understand.
Okay, that's why she's saying that. Give me one moment.
Okay.
There is probable cause. Your bond is $1,000. You can't possess or consume any alcoholic beverage. You'll be subject to random alcohol screens. You can't drive without a valid Florida license. Do you understand?
Okay, so I can't drive. I have lost my driver's privileges.
I said you can't drive without a valid Florida license. So at this time, I don't believe you have a valid Florida license. But if you get one, you can drive.
I have a driver's license.
I think the DUI suspends his driver's license.
Automatically on the DUI.
Your driving privilege gets suspended automatically. So call the number on that piece of paper and talk to your attorney.
Okay.
They can apply, they can ask the judge for a hardship license. There's all kinds of things that can happen, but until that happens, you can't drive.
Okay. Is it possible that due to my background, this is my first charge in years. Is it possible I can get released on my own currency, please?
I'm sorry, what?
Due to my background, I'm asking the court, is it possible that I can be released on my own reconnaissance?
Oh, it is not, sir.
Okay.
I'm looking at your history. I see 2 prior failures to appear. I see several other driving charges. And because of the facts of this case, at this time, I'm not inclined to reduce that, but call your attorney. They can file a motion in front of the trial judge anytime, and that judge can change it.
Okay. All right.
Good luck, sir. Please tell me your name.
Andre Ashley.
Good afternoon. You're here in 21 CF 14085 because a warrant was issued for your arrest, charging you with battery with one prior offense. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, state we just have you take into account, he does have prior battery convictions as well as prior failures to appear.
Your Honor, but if you look, it was all the way back in 2002, and his last conviction was in 2013.
Sir, your bond in this will be $5,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means? Do you understand, sir? You can't possess a weapon of any kind, firearm or ammunition. You can't return to the Walgreens at 4720 South Kirkman Road for any reason. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Yes, Deshaun Bowie. How are you doing today, Your Honor?
Good, how are you, sir?
All right.
I feel like you just saw me in October, maybe. I thought it was me. All right, sir. Today you're here charged with possession of cannabis with intent to sell or deliver, possession of cannabis less than 20 grams, not greater than, and possession of drug paraphernalia. Sir, I reviewed this affidavit. There is probable cause. I'll appoint an attorney to represent you in this case. Does the state wish to be heard on bond? Is he on probation?
Yes.
All right, I show him as a violent felony offender of special concern who's actively on probation. Has there been a VOP warrant?
Your Honor, I believe he's also on probation for a drug offense while picking up additional drug offenses. And recently pled to a.
Which he'll be seen on tomorrow.
It's an on view today.
There has been an on view added on him. No.
Oh, I don't have anything.
Tomorrow.
Oh, he'll be seen tomorrow. Okay. I'm going to tell you what your bond is today, but you're being held right now because the violation of probation is coming. You'll be seen on that tomorrow by Judge Bain. That will have no bond. I just want to make sure you know that.
So I see the judge tomorrow for a violation.
Right.
So I have a violation currently now.
You have it, but it hasn't been served yet.
All right. Okay. I got recently got custody of my kids. Like they in school right now. I don't know what I'm gonna do about picking them up.
You're not going to be able to because you won't be able to bond out today and likely not tomorrow. It'll be in front of Judge Bain, but I believe it'll be no bond. So I'm going to give you bond on this today, but I just want to make sure you know that because even if you post this bond, you can't get out today.
All right.
So hold on, let me tell you what your bond is. So your bond is $1,000 on count 1, $500 each on 2 and 3. You can't possess any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? And then call the number on that green piece of paper to talk to your attorney. But like I said, you're not going to be able to bond out even if you post this bond today. So I just want to make sure you know that.
Okay. And you said there was likely probable cause in this case, right?
Yes.
And what would that be?
The probable cause?
Yeah.
Hold on, I'm going to ask the state to put the factual basis on record.
On or about November 14th, 2021, law enforcement was conducting surveillance when they observed the defendant sitting in front of a 7-Eleven gas station. He walked up to the driver's side vehicle of a red Chevy pickup truck and conducted a hand-to-hand transaction. Once the vehicle left the parking lot, law enforcement did a traffic stop on that vehicle. MDMA and cannabis were found within that vehicle. both presumptive positive. The driver of that vehicle said he made contact with the defendant in a dark hoodie with dreads. He stated he purchased cannabis from that male for $10 in US currency for approximately 3.5 grams of cannabis. Field test presumptive positive for cannabis. A later search of the defendant revealed 13 grams of cannabis located on his person. All events occurred in Orange County, Florida.
So that's the probable cause when you were arrested and they found the cannabis on you?
Basically, I matched the description of someone. And
Hold on, before you say anything else, everything you say is being recorded and it can be used against you later. I'm just telling you what the probable cause is, because you possessed it at the time, and then they have the statement and they observed what appeared to be a hand-to-hand transaction. That's the probable cause.
all right, now I guarantee I have facts. I have witnesses and videos of me not being there at the time they say I made the what would I have to do to bring evidence in?
So I've appointed an attorney to represent you. We're not having an evidentiary hearing today. This is just to establish probable cause. You may have some great defenses to this, and I don't even know if the state's going to file it. So what you want to do is the phone number on that green piece of paper, call your attorney right away, tell them you have several defenses to this, and you need to get with them right away. Because, like I said, you're not going to be able to bond out. You're being held on the VOP. So call your lawyer right away. Good luck, sir. Please tell me your name.
Brandon Matthew Bryant.
Mr. Bryant, you're here in 21 CF 14723, charged with possession of heroin. There is probable cause. I'll appoint an attorney to represent you. All right, I'll stay your bond at $1,000. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Your Honor, I believe this is Cody Randolph from the, we reset him for tomorrow, but I guess he was able to come up.
What section is this from?
Misdemeanor pleables. We reset him for tomorrow for a possible plea, but I guess he was able to be brought up, Your Honor.
Do you have the case number?
2021 MM550AA is what's on my form.
I don't have it, so it's going to take me a minute. Cody is his last name.
Yes.
All right, Mr. Cody, you're here charged with trespass on property after warning. There is probable cause. Did you say there was an offer?
Yes, Your Honor. The offer is an adjudication of guilt, credit time served, and no return to the 7-Eleven. And Ms. Taylor, can you provide the address?
1117 East Cimarron Boulevard.
I did speak to Mr. Cody. He understands the rights he would be given up, and he would like to accept the offer here today.
I don't know that I'll accept that agreement. Give me one moment. You have the address for this trespass?
Yes, Your Honor. It's 1117 East Cimarron Boulevard.
Is that near 380 Cimarron Commerce Place?
I'm not sure, Your Honor.
All right, Mr. Cody, please raise your right hand.
Yes.
You can put your hand down now. You had a chance to speak with an attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand that if you're on probation anywhere, this plea could violate that?
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right, sir, at this time, how do you wish to plead a trespass on property after warning?
No contact.
No contest? You can plead guilty, no contest, or not guilty.
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
1 day.
1 day that you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. You can't return to the address. Did you already put the address on the record?
Yes, Your Honor.
All right, you can't go back there, you understand?
Yes, yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing. Please tell me your name. What's your name, sir?
My name is Philip Caldwell.
You're here in 21 CF 14715, charged with 2 counts of sexual battery on a person greater than 18 by a person greater than 18 years of age. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, these are both first-degree felonies, so he is otherwise entitled to bond as they're not PBL or capital. But given that they're sexual in nature, state's just asking for a reasonable bond. I believe he has limited to no criminal history. However, it does appear that he's not from the direct area. So I'm unsure about his community ties and his ability to show back up for court. So state would just have you take all that into account when setting his bond.
Your Honor, I believe his mother verified his community ties and employment. I would just ask that you take into consideration his criminal history. He has none in his on the case sheet when setting the bond.
Sir, your bond on count 1 will be $100,000. Your bond on count 2 will be $50,000 with special conditions. Does he have an attorney?
He stated that his attorney said he would be here at 1. So you want to?
Oh, we can pass it and come back.
Yeah.
All right, we'll come back to your case, sir.
Your Honor, Erica Deere, bonded.
All right. Good afternoon, sir. Please tell me your name.
Deshaun Ups.
You're here in 21 CF 14726, charged with carrying a concealed firearm. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess a weapon of any kind, firearm or ammunition. You can't possess any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes.
Good luck. Good afternoon. Please tell me your name.
Michael Macon.
You're here in 21 CF 14736, charged with driving while license suspended and driving under the influence of alcohol. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, I would ask for a pretrial release in order to lower the bond amount, given that it appears he is unemployed.
When was he released from DOC?
I couldn't see that in the DOC website.
I show 3 prior failures to appear. He was released from DOC, but I don't know when, for trafficking in cocaine. His last conviction was just in May of this year.
Your Honor, there's also several probation violations. I don't know if you make a good candidate for pretrial release, given the failures to appear and the violations of probation, showing an inability to comply with court orders.
I'm not asking for straight pretrial release. I'm just asking that you place him on pretrial release in conjunction with that bond to lower the bond amount, Your Honor. So I'm asking for both.
All right. I will place you on pretrial release and require that you post a monetary bond. However, I'll reduce it. Count 1 is it's a felony. It's a third-degree felony. I'll reduce that bond to $500, and count 2 will be $500 as well. With special conditions, you can't drive without a valid Florida license. You can't possess or consume any alcoholic beverage or any controlled substance without a valid prescription, and you'll be subject to random drug and alcohol screens while on pretrial release. Do you understand?
Yes, ma'am.
Good luck, sir. Good afternoon. Please tell me your name.
Angela Lee Markham.
21 CF 14725. Ma'am, you're here charged with aggravated assault with a deadly weapon, battery, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Does either party wish to be heard on bond?
Does she not qualify still?
It says she doesn't qualify.
Yes, they didn't qualify her.
Oh, okay.
After they.
Interview, okay. No, Your Honor, I just ask that you take into consideration there is reported mental health history, and she has no criminal history. And it looks like she does have community ties. She lives with her mother. She's been there for over a year. So I just ask that you take that into consideration.
Ma'am, you can say anything you wish, but everything you say today is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
I'll give you a moment to converse with your attorney. Was there anything you wanted to say after you talked to your attorney?
She was just stating that she lived with her mom for 5 years.
Okay. All right, ma'am. Your bond will be $1,500 on count 1. I'll treat the others as subsidiaries. That'll be $100 each with special conditions. You can have no contact with any victim or witness in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Are these your neighbors?
Yes, ma'am. Like 5 blocks over.
5 blocks over?
Yes, ma'am.
Okay, so if I order that you can't return to their residence for any reason, that won't interfere with your ability to be able to go to your house, right?
No, ma'am.
Okay, so that's what I'm going to order. Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. Oh.
Stevenson, Mark, bonded.
Sir, please tell me your name. 21 CF 14737. You're here charged with aggravated fleeing or attempting to elude law enforcement, causing injury or property damage, reckless driving, and no motor vehicle registration. At this time, I'm going to appoint an attorney to represent you.
Your Honor, I am going to ask for pretrial release. However, I know he has, on his charge, he has the aggravated fleeing and eluding with the property damage. So I understand his bond amount in conjunction with that pretrial release will be higher. However, I will ask that you reduce the bond amount if you place him on pretrial release, given that he lives in the Deltona area, which he lives in Florida. No prior convictions or even arrest on his face sheet, 0 photos to appear. So I just ask that you take all of that into consideration.
What says the state?
Your Honor, state has no objection. You place him on pretrial release with bond. However, what the state would ask for a higher bond on count 1 due to it being an aggravating fleeing and attempting to elude due to the property damage.
Yeah, this is part of that whole group we were discussing earlier. I just think it's a miracle no one died.
Yeah, sure.
But as far as I can tell, no one did. All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I will reduce that amount significantly. So your bond on count 1 will be $7,500. Counts 2 and 3 are straight pretrial release. Count 1 is pretrial release and bond. With special conditions, you can have no contact with any co-defendant or witness in this case. Do you understand what no contact means?
It's my first time, so I mean, not truly. You said no contact, I know what that is, but you think co-defendant, I don't know.
So all of the people who were involved in this incident, driving recklessly on ATVs and motorcycles at high speeds, doing stunts, racing, all of them, you can't talk to any of them. So I don't know if you're related to any of them, or if they're your friends, or I don't know who they are to you, but you can't have contact with any of them. Don't speak to them, don't text them, don't call them on the phone, don't send messages on social media, no contact. You can't return to this area for any reason. And right now, you can't drive in the state of Florida. Do you understand? All right, good luck, sir. All right, Mr. Rhodes, just a moment. We're back on the record with Mr. Peters. And yes, sir, Mr. Rhodes.
I've provided this to the state as well. The case site is 203 Southern 3rd 201, 4th DCA case, Lulu v. State, or yes, Lulu v. State, LULU.
All right. And what's your argument with regard to that case?
In Lulu v. State, a 4th DCA case, there was an accident in a jointly occupied vehicle. When the police showed up, they saw what appeared to be drug paraphernalia, which was a pen wrapped in, I guess, tinfoil, which tested positive presumptively for cocaine. And this, when the putative defendant made statements, she said that the car, much like the situation here, allegedly, the car belonged to her sister, but she used the car primarily. So this is a person that's saying like this, like essentially, this is my sister's car, but I use it. And she had admitted to having specific control over the car. The paraphernalia was found in the driver's side rear floorboard, and they were saying that this court thought that was in plain view, but there's no evidence of that here in the affidavit. Even it being on her side of the car, and the defendant admitted and tested positive for using cocaine the day before, which is consistent with what the paraphernalia tested positive for. The court on a prima facie stand found that the appellate court found that the trial court, even on a prima facie standard, erred in not granting the judgment of acquittal. So we have facts that are similar to the case here, where this person says, "This is my car." There are statements attributed to Mr. Peters saying that he drove the car, or that the person that was in the passenger seat said he drove the car. So even assuming that he had control of the car, in this case, the appellate court recognized the fact that she had said that she had control of the car. She was driving the car, but the paraphernalia found in a place that was more accessible to her than the drugs in this case were accessible to my client. They found that there was not sufficient evidence in a jointly occupied vehicle of constructive possession. And again, that is under a prima facie evidence standard, not the standard that we're operating here, proof evident presumption grade. So given those facts, I think that, especially the fact that this is a vehicle that she said was in her possession, and the appellate court found that not to be sufficient in order to establish constructive possession.
Okay, give me one moment. I need to read part of this. All right, Miss May, any response from the state?
Yes, Your Honor. First, I don't have any case law to present to the court. However, I did look over the case law that was provided from defense. First, the case that was provided, the alleged paraphernalia was in the back seat, which is different than the circumstances we have today. Also, the difference in paraphernalia versus a large amount of drugs. In this case, we have 83.5 grams of meth and approximately 275 grams of cannabis. So those facts are distinguishable by our case that we have here today. Second, even though the facts are similar in that this wasn't arguably Mr. Peters' vehicle, it did belong to someone else. However, he did have the keys to the vehicle and arguably could exercise dominion and control over said vehicle due to having keys of the vehicle. In addition, there was the strong odor of cannabis from the vehicle that law enforcement noticed as he walked up towards the vehicle, and the defendant did have cannabis on his person, and there was cannabis also on that floorboard, which could be an independent way to tie Mr. Peters to the cannabis that was also within the floorboard, as he also had some on his person. In addition, there is the inconsistent stories between the defendant that he gave to law enforcement regarding the Dodge Ram story, and saying at one point it belonged to his baby mama, one point belonged to Dwayne Scott. The independent witness or co-defendant, or however we want to refer to him, said that that story was not true, that he was picked up approximately 30 minutes, I believe it was 30 minutes prior. And there was no Dodge Ram, no one else was driving, no one else was around. Only Mr. Peters within the vehicle when he was picked up. So under the totality of the circumstances, state has to prove he knew or should have known the drugs were in there, and he had the ability to exercise dominion and control over them. State would just say in the totality of the circumstances of him having the keys, inconsistent statements, the odor of cannabis, which showed that he knew or should have known that there was potentially other cannabis within the vehicle, and there was cannabis in his pocket as well as in the floorboard. State would contend that there's enough for prevailing presumption great for the trafficking and meth due to all those things, due to he knew or should have known, and he had the ability to exercise dominion and control based off of the witness's statement.
Did either of you find if there's a fifth DCA case?
Everything I was finding was mostly second and fourth.
That's what I'm finding too.
There's not much out of the fifth, Your Honor, that I could find that was on point. They're also arguably in plain view, and how the defendant and the witness acted when law enforcement arrived can all be taken into account. That he knew or should have known that they were in there.
So I'm reading the facts of this case, and there was a car accident, and the paraphernalia was found on the driver's side rear floorboard near the center console. So it was behind both the driver and the passenger, who was seated in the front passenger seat. The appellate court found that knowledge and control cannot be inferred solely from the defendant's proximity to the contraband in a jointly occupied vehicle. Rather, the state must present independent proof of the defendant's knowledge and ability to control it. A tie between the contraband and the accused is a critical factor in determining the ability to exercise dominion and control. And it looks like they're quoting from others of their cases. The fourth DCA in this opinion.
Also pretty standard across the board, Your Honor, in all the DCAs.
I wanted the record to be clear. I'm not saying that's their new language in this case. They're quoting from other cases of opinions they've written. In a case of a jointly occupied vehicle, quote, even where drugs are found in plain view, the evidence will be insufficient to establish constructive possession unless there is evidence that the defendant exercised dominion and control over the drugs. That's from Marital v. State, 946 Southern 2nd, 1240. And then the court says, recently we reversed a conviction for possession of a short-barreled shotgun found in the trunk of a car, saying the trunk is not a place where the defendant had immediate control because nothing in the trunk tied him to the shotgun. So that seems distinguishable from our case here, because in our case, the drugs are found on the passenger floorboard in plain sight.
I understand what the court is saying, but there's nothing in the arrest affidavit that says that they were in plain view of the defendant.
Okay, hold on, what does it say?
The court in Lulu felt that the drugs were in plain sight there. I'm just drawing that distinction from the facts as the court found them in Lulu versus the facts in the affidavit.
I'm reading from the affidavit in the
Yes,
instant
ma'am.
case. On the front passenger seat floorboard, a gray plastic bag was located. So it does not say in plain sight, but it says on the front passenger seat floorboard. So there doesn't seem to be any indication that it's not.
It doesn't appear it was concealed under the seat, I believe.
Right, it doesn't say concealed under something or. Also in this case, we have the same type of drugs found in that bag are found on your client. One of the types of drugs that's found in the bag is also found on your client. Let me go back to this case. Give me a moment. The shotgun was not in an area over which the defendant had immediate control. We reversed his conviction because nothing in the trunk tied him to the shotgun. Arguably, the defendant's wallet, the keys to the car, and the same type of drugs in his pocket as was in the plastic bag tie your defendant to the plastic bag.
Well, Judge, may I be heard on some of the factual
Yes.
points you're making? So, number one, whether it's a trafficking amount of drugs or paraphernalia, since the trafficking amounts of drugs in this case were in small containers, apparently. I don't think there's any distinction to that. Is to the issue of him having the keys in his car. Again, based on the court's finding in Lulu, that is not determinative in any sense, because there is better evidence in Lulu that person had control of the car, because she specifically said, it's registered to my sister, but I drive it. So the court does not give that factor much credence in the Lulu case. As to the fact that he had cannabis on his person, we're not contradicting the fact that he had cannabis on his person. But what I would note for the court is that the affidavit contains no facts to say that the cannabis that was found in his pocket, and the amount is, I think, 10 grams is what's alleged in the
I
affidavit.
think it is 10 grams, yes.
Is number one, it's an amount that has nothing to do with what's in the floor. There is no indication it's the same packaging. There's no indication that, like, the rubber bands are the same, the packaging is the same, it's packaged in the same way. There's no indication that it's the same type of marijuana, that the marijuana looks similar. Lots and lots and lots of people run around with 10 grams of marijuana in their pocket. As the court knows, you see people arrested for misdemeanor amounts of marijuana 6-7 times a day, probably. So the fact that he had a misdemeanor amount of marijuana without the affidavit drawing the line between the type of packaging or something else, again, there's not enough information in the affidavit for I think for the court to give that particular fact any particular amount of credence. Since if the affidavit is silent to the issue, the court can't make the logical leap to assume that there is some sort of evidence that ties one to the other. They had the opportunity to say that they were packaged the same way, it looked the same, it smelled the same. They could have done that. They chose not to. It's not present, so that there's a dearth of evidence for the court to consider with regard to that fact. And there is case law, Judge. I don't have it. I can find it quickly. But there is case law that says that the fact that a jointly possessed vehicle smells like pot is not a factor to determine that pot found in the car belonged to the person who's charged with.
Well, I don't think, and Counselor, you said earlier that it's not determinative. I don't think any one of these facts is determinative. But the court is now in the position of fact finder for purposes of this type of hearing. And is it possible that a law enforcement officer would write that the cannabis in his pocket smelled the same as the cannabis in the bag? I suppose that's possible, but I don't think that's determinative either. And I don't think if I was the juror in this case, if I'm the fact finder, I would need to know that the cannabis smelled the same. I think all cannabis does smell the same. So is it possible that the cannabis in his pocket had nothing to do with the cannabis on the floorboard? Yes, that's possible. Is it reasonable? Not to this court. I think looking at this affidavit, reading it, and putting together all the factors in the affidavit from the very first moment that law enforcement observes your client open the driver's side door to the vehicle as if to get in and then doesn't. That's the very first time that he demonstrated his dominion and control over the vehicle. Then the search yields that.
I'm sorry.
Go ahead.
Exercising dominion and control over the vehicle is very different than the exercising dominion and control over the contents of the passenger side floorboard.
It can be, yes. But then upon searching your client, they find a gun.
Yes.
And they find cannabis. And then they find cannabis on the floorboard of the vehicle that your client has the keys to, that he opened the driver's side door to. It's found on the passenger seat floorboard. His wallet is found on the driver's seat floorboard. So in every practical way, your client is exercising dominion and control over the vehicle. I understand you're saying that's different than what's inside the vehicle. There's also a scale found in the center console. Your client tells law enforcement that, of course, it is not his vehicle, but his, I believe he says, baby mama's vehicle. I understand he later changes that story to her brother, Dwayne Scott, owns it. But all of those things are your client telling law enforcement that why he is in possession of the vehicle as opposed to the passenger being in possession of the vehicle, because it's his relation that owns the vehicle. Your client then says to law enforcement, which I would assume is on some kind of recording, although we don't have that today. He says, "Did you tow my car?" referring to the Audi. So I think there's no doubt that your client is exercising dominion and control over the vehicle. I think this case, the facts in this case are distinguishable from the Liu case in that case, the paraphernalia was found behind both the driver and the passenger. In this case, it's not. It's found in front of both of them. It wouldn't be behind them where they may not be able to see it. So I think that's distinguishable as well. I understand that the odor of cannabis, burning marijuana, is not dispositive that whatever drugs are in the vehicle are the ones that were being burned. But I do think it's also a factor that law enforcement has to consider. I tried to, as I told you, put myself in the position of the fact finder and come up with any reasonable doubt that your client is in possession of these items. I can't find any reasonable doubt, counselor.
Judge, I have to point out for the record that reasonable doubt isn't the standard.
I understand that, but to get to proof evident presumption, great. We have to get past reasonable doubt, right? So if we're looking at it as a stair step, we have beyond probable cause, which we all agree that's not the standard for this hearing. Then reasonable doubt would be the next one. So what I did was put myself in the position of the fact finder, because obviously if there is reasonable doubt, then we're definitely not going to get to proof evident presumption great. I can't find any. So I think there is proof evident presumption great here. However, even having made that finding, it is within the court's discretion to give a bond. If you want to make another argument for bond, I'm happy to hear that.
Yes, Judge. In terms of his bond, there's no indication that he is a flight risk. He is a lifelong resident here. He is employed, works for a paving company. He has his entire family lives here. He has a very minimal criminal history. He has no record of violence. He has no felony convictions whatsoever. If I'm not mistaken, his convictions are possession or like misdemeanor possession of cannabis charges.
I think that's right. I don't see any adult convictions for anything else. But I don't have any evidence of those things that you're telling me about his ties to the community. Do you want to take testimony so the court has evidence to consider?
Yes, ma'am. I can take testimony from my client.
All right, sir, please raise your right hand.
Yes, ma'am.
All right, go ahead. You can put your hand down.
Please state your full name for the record. All right, Mr. Peters, tell me about the amount of family that you have in the Orlando area. Kids, family, your brother, or your mom.
Brother, sister, siblings, 6 young kids. I have custody of 3. And, joint custody of my other 3.
Okay. And do you support all those children?
Yes, sir.
And where are you employed?
For material, I'm a street paper operator.
Okay. And how much money do you make there?
19 hours.
Okay. You work 40 hours a week, 50 hours a week?
Yes, sir.
About what do you work, I guess is my question.
40 to 50 hours.
40 to 50, okay. Do you have a passport?
Yes, sir.
Would you be willing to turn your passport in should the judge make that a condition of your bond? Okay. Would you be willing to abide by any conditions that the court would set and found that she found appropriate in terms of making sure that you're going to come back to court?
I'm sorry, I couldn't hear him.
Yes.
I was assuming he said yes. He was
Yes,
nodding
ma'am.
his head, but I couldn't hear that, so thank you.
Certainly.
And I'm sorry, counsel, did you ask this? Is he from here?
Yes, ma'am. He is.
Okay, thank you. Does the state have any questions?
Not for the defendant, no, Your Honor.
Okay. All right, thank you. Does the state have any other argument?
Yes, Your Honor. According to, I know this court isn't bound by the bond schedule, but since you are inclined to otherwise set a bond, even though it is a first-degree felony that's punishable by life, the bond schedule says for methamphetamine between over 28 grams, which is what we had in this case. I believe he allegedly had 83.5 grams with a weapon. The bond schedule says it's no bond. However, $200,000 is with a weapon. In addition to it, how do you take into account? He does have at least 4 prior failures to appear. So state's concerned about his willingness to show back up to court. I do understand he has retained private counsel. However, that is still concerning as there are at least 4 prior failures to appear, as well as it looks like at least 4 prior VOPs, showing inabilities to comply with court orders and to. In addition, I do believe he did have some violent history within his juvenile arrest history. However, they would not be on his score sheet today due to being at least 5 years old. All of his other history does seem to be driving related. Willis's false IDs to Leos, no valids. A 2005 sale and manufacture, deliver a controlled substance that was withheld. That was here in Orange County. He had some other prior arrests that were null prost, that were felony arrests, as well as additional driving dualices, no valids, expired driver's license. In 2011, he had the possession of cannabis. Under 20, it was a withhold. In an additional 2013, possession of cannabis. Under 20, that was a drop. In 2014, in Osceola, he was arrested for paraphernalia, cannabis, proceeds of prostitution, renting space for prostitution, aiding and abetting prostitution, agbat, and possession of cannabis under 20. In that case, he was only adjudicated for the paraphernalia and cannabis. 2016, he had another possession of cannabis. And then that leads us to date. So while he doesn't have arguably a lengthy history, there were several violent arrests and felony arrests that ultimately were pled down to something else. Also, many prior cannabis arrests and withholds. So state would have you take that all into account with his failure to appear and his VOP, as well as what the bond schedule holds.
In order for something to be pled down, doesn't that have to be in agreement with the state of Florida?
Yes, Your Honor. I'm on CCIS, so I'm not looking into the actual case and what happened with it. If it was a trial, I don't know. It just says that the disposition was a withhold. I'm not sure if that was a plea with the state or a bench, or I'm not sure, or a trial. I'm not.
All right. Mr. Rhodes, where does your client live?
5284 Champaign Circle, Orlando, Florida.
Is that anywhere near 5219 Ashwood Place?
5219 Ashwood? No, ma'am.
Where this took place?
No, ma'am.
All right. All right, sir, I am going to set bond in your case as a result of your attorney's arguments. It's not going to be what you asked for, but I will set bond. Your bond on count 1 will be $150,000. I will treat the others as subsidiary offenses. So count 2 will be $150, count 3 and 4 will be $100 each. With special conditions, you can have no contact with Neville, his last name, Manning. You can't possess a weapon of any kind, firearm, or ammunition. You can't return to this scene for any reason at all. You can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens through pretrial release. I will order that you must surrender your passport to law enforcement within 24 hours of your release. I'm sorry, the clerk's office. Sorry, I was reading and talking at the same time. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you, counselor.
John, I want to thank you for the amount of attention that you gave this matter today.
Absolutely. Have a nice day. Thanks for coming. Good luck, sir. Witness.
Good afternoon, Your Honor.
Good afternoon, counselor. If you want to go ahead and put your appearance on record. Oh.
Yes, my name is Jeremiah Allen. I'm here on behalf of Philip Caldwell.
Mr. Caldwell, you're back here. We started to address his case, and then he told the public defender that he had an attorney, so now we're going back. So this is 21 CF 14715. I already found probable cause. Did you wish to be heard on bond, Counselor?
Your Honor, I understood that you already talked about an amount there. If I could just tell you, if you've already ruled, I don't want to take up too much of your time, but just a few things about Mr. Caldwell. Number one, he has lived his whole life in Connecticut. He was working. Can I take off my mask, Your Honor?
Yes.
Sorry, it's hard to get through that. He was working from home for a finance company that's based in New York City. Spent the majority of his life in the New York City, Connecticut area. He has a college degree from the University of Connecticut and also a master's degree. He's a licensed CPA as well, and had some other licenses to sell securities. He has the financial means to come back to Orange County whenever necessary, whenever the court needs him to come back. I do not believe any prior record, so we just ask the court to keep those things in mind.
All right, thank you. Does the state wish to be heard on bond in this case?
Your Honor, I believe what was previously set before Mr. Caldwell told the court that he did have an attorney was reasonable. Previously, since they're both F1s and they're both sexual in nature, I believe Your Honor previously set $100,000 on count 1 and $50,000 on count 2. State believes that's reasonable given he's not from the immediate area and given that they are sexual in nature offenses and the allegations that are within this affidavit.
Hold on, I wrote down that I set 150. Oh, I said 100,000. Okay. I'll abide that then. Sir, your bond is $100,000 on count 1, $50,000 on count 2. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means? You have to answer out loud.
Yes, Your Honor.
You can't return to 3300 South Orange Blossom Trail for any reason. You can't be within 1,000 feet of the victim's residence or place of employment. You can't return to a loft at 500 Orange Avenue for any reason. You can't possess or consume alcoholic beverages or any controlled substance, and you'll be subject to random drug and alcohol screens. Are there any other conditions the state would request? Did I say no weapons, firearms, or ammunition?
Your Honor, can I hear briefly on the witness issue? There is one witness involved that's a friend of his that this all kind of stems from being at a concert. His name is Dan. Dan Shears. So we would ask if he could have contact with that person who he knows from St. Petersburg.
I don't think I have that name. What says the state?
Your Honor, the state believes that the condition of no contact with victims or witnesses is reasonable, definitely given that they are first-degree felonies to prevent potential witness tampering issues.
Is that person a witness in this case? Because I don't have that name.
Yeah, that name's not on the affidavit, but they are. He was at the concert with his friend Dan. So that's the only that person Dan is going to help him kind of get his wallet and things together over in St. Petersburg. That's the only reason we need contact for that person.
Do you know if that person wrote a witness statement?
I don't know.
Okay. Hold on 1 second, because it says. Oh, no, he's the unknown male. Okay. I understand the state's reason for requesting it, and that is why I order it, but I don't believe he's an actual witness in this case. So I don't want the defendant having contact with any listed witness.
Understood, Your Honor.
But I don't think this Dan is a witness.
He's not an actual witness to the alleged sexual battery. He was just around his friend Dan prior to the allegations.
All right, so I'll allow you to have contact with him, but no other victims or witnesses in this case.
Understood.
All right. Anything else from the state?
No, Your Honor.
That's all we have. Thank you, Judge.
Yes, sir. Thank you. Good luck. Anything else from the state or the public defender before court is adjourned?
Nothing from
No, Your Honor.